Good afternoon. As Bruce noted, I am Rebecca Kelly Slaughter, and my first order of business is to note that the remarks I'm about to deliver represent my own views and not those of the Commission or any other commissioner. So thank you to the chairman for convening today's hearing and these hearings writ large, and to everyone at the FTC, particularly our staff in the Office of Policy and Planning, for the monumental effort they have put into carrying out this ambitious endeavor. Thank you to the panelists who are here today to share their knowledge, expertise, and views about merger retrospectives. Some of you have been repeat players at our hearings, and we appreciate the time and effort you've given to this task. Today's discussion of retrospectives is a key way these hearings can fulfill their mission, as described by Chairman Simons, to examine and evaluate the effectiveness of our enforcement, and, where we identify areas for improvement, to implement reforms. As I said at the second hearing way back in September, these hearings cannot simply reaffirm our current policies and practices with a pat on our back. Any serious and credible wide-scale review of our enforcement and policy record must be able to identify ways in which we can improve. This morning's panels, and I'm sure this afternoon's panels, will as well involve extremely sophisticated and detailed economic and legal discussions of merger retrospectives. I'm going to take us in a completely different direction for a moment. If any of you are or have recently been the parents or relatives of preschool-age children, you may be familiar with the show Daniel Tiger. Daniel is the cartoonized son of the puppet tiger on Mr. Rogers' Neighborhood, with the PBS show with which many children of the 60s, 70s, and 80s grew up. Anyway, Daniel is the current generation's version, and using the concepts and themes pioneered by Mr. Rogers, he teaches extremely helpful life lessons in 15-minute segments, each punctuated by a unique summarizing song. I personally have discovered that there is a Daniel Tiger song for basically any situation, including, as it turns out, how to think about antitrust enforcement and merger retrospectives. A very frequently cited Daniel Tiger refrain in my house is a one about making mistakes, and I will embarrass myself by singing it for you. Wow. It goes, "It's okay to make mistakes, try to fix them and learn from them too." I did not have an alternate career as a singer, and will not surprise you to know. These are wise words for children, but they're important for adults as well, including antitrust enforcers. And while I would not say enforcement mistakes are okay, they are certainly inevitable, since merger review is generally an exercise in predictive analysis about how markets will operate after a proposed transaction is consummated. This predictive nature provokes reference to the well-worn quotation that prediction is hard, especially when it's about the future. This quote has been variously attributed to Yogi Berra, Mark Twain, and apparently Niels Bohr has a claim to it as well. This is what the internet has taught us. It resonates because even though we use our best economic and legal tools to make the most accurate predictions we can, we know that sometimes we may make mistakes. Of course, sometimes the evidence gathered in a merger investigation unambiguously predicts clear competitive harm that requires enforcement action. For example, in the Tronox matter, the Commission successfully argued before several courts that the elimination of crystal in the North American titanium dioxide market would have harmed competition. Just this week, the Commission announced a unanimous settlement that required a clean sweep divestiture of the relevant crystal assets. In other instances, accurate prediction is substantially more difficult. While our predictions need not be absolute, correctly divining how a proposed merger will change firm behavior and market outcomes, especially on non-price factors like quality and innovation, can be extremely challenging. Recent vertical mergers illustrate this well. In the vertical context, predictions about how changes in firm behavior will influence competition are often more complicated and maybe less clear. Two people, in good faith, can disagree about the merits of a given prediction and ultimately the propriety or legal viability of enforcement action. But what I think we can all agree on is that the Commission's predictions and its enforcement decisions can profoundly impact competition and consumers for many years. There is an enormous weight on our shoulders to make the right decision about the fate of a merger. This responsibility extends beyond the time at which we evaluate proposed mergers. It also requires us to improve upon our predictions and to correct erroneous decisions that resulted in competitive harm. And this is where we would do well to heed Daniel's call to try to fix our mistakes and learn from them too. That is precisely what merger retrospectives can do. They can help us to check our work, to test the accuracy of our predictions about a given merger. They can help test the usefulness of our models and other tools of analysis to inform future merger investigations, which, as Chairman Simons noted this morning, affirmatively helps our enforcement efforts. The hospital merger retrospective study initiated by Chairman Muris, which resulted in a new strategy for successfully challenging anti-competitive hospital mergers, can and should serve as a model for how to tackle other enforcement challenges facing the Commission. Another good example of how retrospective analysis can be useful to improve prospective enforcement is the recent remedies study Angelique discussed in the last panel, from which the Commission learned several important lessons about ensuring the success of divestitures. Importantly, retrospectives may also be able to help us determine not only how to handle new cases in the future, but whether, in a specific case, further enforcement action, such as unwinding a consummated merger or challenging anti-competitive conduct, is necessary to protect and restore competition. I appreciated the discussions this morning of different types of retrospective analysis, including not only the traditional modeling that relies on control markets, but also simulation models. I am particularly interested in retrospective reviews that allow us simply to compare a market post-merger to our own predictions about what would happen at the time we evaluated the transaction. This type of review may be particularly useful in vertical cases when our merger analysis rests on assumptions not merely about price, but also about the behavior of merged firms. Did we rest our conclusions on an assumption that the merged firm would not engage in a foreclosure strategy when later we can observe that it did? Did we assume entry by third parties that would keep competition vibrant when no such entry in fact occurred? To the extent that retrospectives can help us to improve our predictive tools and analysis and correct prior decisions, we need to do more of them. And given the increased complexity of analyzing vertical integration, I believe we should focus our resources on reviewing our enforcement decisions regarding vertical mergers. Furthermore, if we make clear at the time a vertical transaction is cleared that it will be the subject of a future retrospective review, that may have the benefit of a disciplining effect on the merged firm. I appreciate that this may be unsatisfying from the academic perspective of looking for robust data, but I would be willing to assume that cost for the benefit of protecting competition. I actually don't think anyone disagrees with the idea that more merger retrospectives would be a good thing, although I may be proven wrong. But I recognize the significant resources that retrospective examinations require. I support Chairman Simons' advocacy for more resources and his willingness to find ways to work with outside researchers who wish to conduct value-add merger retrospective studies. I know I sound like a broken record on the topic of resources, but that is because it bears repeating again and again. When I first got to the agency, almost exactly a year ago now, I spent time meeting with staff across the bureaus. I asked everyone I talked to what they thought the greatest enforcement challenge they faced was, and resources was the resounding refrain. The numbers bear this concern out. Over the past several years, merger filings have increased and the cost to investigate and challenge anti-competitive mergers has skyrocketed. Yet our funding levels have remained largely flat, which in reality is not flat but declining because each year the cost of compensation and benefits for the same number of employees rises, so flat funding provides for fewer staff. This means specifically that the Bureau of Competition staffing levels have decreased in recent years. But despite this headcount decline, the FTC's workload has increased. Since 2010, the number of pre-merger filings has more than doubled. And this statistic does not reflect the many additional mergers we investigate that fall below the Hart-Scott-Rodino reporting threshold. That said, the FTC's staff, dedicated staff, works tirelessly to do more with less. Last year, they litigated 4 conduct cases and 3 merger challenges and prepared to litigate an additional 3 mergers before the parties abandoned the transactions. So what does this have to do with merger retrospectives? As Bruce Kobayashi, the director of the Bureau of Economics, and the gentleman who introduced me, said on a recent ABA panel, the resource crunch has required the Bureau to devote more resources to investigations and enforcement. This means less research and fewer merger retrospectives. We should work with Congress to reverse this trend and ensure we're able to devote an ample and reliable stream of additional resources to our merger retrospectives program. With an increase in funding of $50 million annually, the Commission could not only supplement its Merger and Conduct Division staffing, it would be able to reboot its retrospective analysis by adding more attorneys and 10 economists to the effort. But we cannot and should not wait for our resources to increase to consider whether and how we can retool our enforcement efforts now, including our retrospective analysis. The panels today have been and will be incredibly useful to informing the Commission as to how we can be most effective in undertaking retrospectives and how they should inform our enforcement mission. The questions in which I personally am most interested include: should we look at more mergers that were not challenged following significant investigations? How would a vertical mergers retrospective program help hone our investigatory techniques? What kind of information would best assist our retrospective efforts, and what are the sources of and most effective means of obtaining such information? And how should we think about retrospectives in industries that are marked by rapid and significant technological change? On this last question, I want to emphasize an additional point. The Commission must often review mergers in technology-intensive industries well before they have matured. And I want to be clear, I'm saying technology-intensive industries because I don't think technology accurately describes any industry anymore. It is too widespread, crosses too many different fields. But retrospectives may be particularly useful to inform our understanding of how these industries evolve and how mergers in the early stages of such industries' life cycles affect nascent competition and influence industry structure, growth, and dynamism. In this way, merger retrospectives can support our other technologically focused enforcement efforts, such as the Bureau of Competition's Technology Task Force. So I will look forward to hearing from this afternoon's panelists, and thank you again to all of today's participants.
Thank you, Commissioner Slaughter, for those really insightful remarks. Welcome, everybody. Good afternoon. This is now session 3 of today's hearings, entitled, Should the Findings from Merger Retrospectives Influence Horizontal Merger Policy, and if so, how? I'm Mike Vita. I'm a Deputy Director here in the Bureau of Economics, and we have a really great panel for this session. So I'll just quickly name everyone. Orly Ashenfelder from Princeton, Steve Berry from Yale, Limor Daphne, who you met this morning, from Harvard, Debbie Feinstein, the sole attorney on the panel from Arnold and Porter, Aviv Nevo from Penn. It's a great panel, not only some distinguished academics and a distinguished attorney in Debbie, but a lot of enforcement experience as well as academic experience. Limor, Debbie, and Aviv have all worked here at the Department of Justice as enforcers, so they have a really good understanding of the importance of these kinds of studies and how they can affect what the enforcement agencies are asked to do. So let me just step aside then. Orly, I'll let you go first.
Alphabetical, right?
It is.
I have no slides, and that's very unusual for me. But I'm not going to talk about data. This is 10 minutes that I'll take, I hope not longer, to talk a little bit about some policy issues and some more general issues related to merger retrospectives. The first point there, I want to make 4 points. The first point I want to make is that to some extent, the methodology associated with retrospectives is associated with accidental opportunities to evaluate some merger. My first association with the idea, really, was using retrospective mergers to actually challenge a merger. And that was the Staples Office Depot case. I think I was involved because my good friend Jerry Hausman was an econometrician working for Staples, and there was a belief I could crunch numbers too. Probably not as well as he could, but good enough. That situation was very unusual because at that time, completely opposite of today, those firms were expanding, and there were many examples where one or the other would open a store in an area where this format, the brand new format for, you may not remember now, but back in the day there used to be stationery stores. They're all gone now. As the format expanded and disrupted that whole industry, there were plenty of examples where one of the large superstores existed and another one would come in, and we could actually look and see what happened to the prices. There was plenty of good anecdotal evidence that attorneys had turned up on what managers were supposed to do faced with this new form of competition, even telling them how much they should reduce their prices. The econometrics fell in line with it too, and because there were many examples of stores that had opened across the country at different points in time, we could study those examples. They were retrospective merger evaluations, but they were used as a challenge for the merger going forward. So that was an example that it excited me because it was an extremely unusual example which we'd normally never run into. And then it opened my own eyes to the idea that you could probably do that in some other cases, but that as a more general matter, the opportunity to study retrospectively what happened to mergers was something that could be done on a broader basis, and probably should be done on a broader basis to inform us about how successful the merger enforcement efforts have been, but also to help us a little bit about, in learning about, if possible, where mergers were more or less likely to be problematic. At that time, this 20 years ago, by the way, it was exactly 20 years ago that case took place, 1999. At that time, there wasn't much to use as an alternative, and I'm always fond of this agency because I've worked with some of the people in it, like Dan Hoskin, Matt Weinberg, who was here for a while. I know Bruce Kobayashi, in fact. We taught together for many years and trying to teach statistics to judges. Probably not successfully, but at least we're probably still trying. And I'm probably the only person here who's actually done work for the FTC, not just in merger issues, but in the fraud squad. I was involved once with a scam that the FTC shut down that involved trying to resell large quantities of wine to consumers as guaranteed investments. Unfortunately, the FTC did not shut down this operation until I learned about it when they had already stored away 30,000 cases of wine. They didn't actually shut it down until there were 130,000 cases in an unrefrigerated warehouse in San Jose, California. A whole lot of fine alcohol went down the tubes. So the first thing I wanted to say, first point is that I think it's inevitable that retrospective analyses are going to have to be opportunistic because it either depends on the data or it depends on the opportunity to study something which is unique to a particular industry. It always has to be fact-intensive and difficult. So I think there's nothing that you can say that gets you past the fact that it's always going to be opportunistic and to some extent like a case study. Now, the panel before mentioned case studies can be really good, and I'll come back to this. For learning a little bit about how industry operates, many times we don't really understand exactly the theory that helps to explain the way an industry works. But that's the first point I want to make. I don't think there's any way you can get around that. Second point I want to make is, with respect to public policy, in some sense, it's inevitable that merger retrospectives affect public policy. We all know that's really true. Because what we have observed is when we started doing retrospective analyses, we were seeing price increases where there was a wide group of people who thought that all mergers led to price decreases, Robert Bork amongst them. Bork's book is factually intensive. He seems to think he knows what the effects are. Clearly, it was not based on any facts at all. But his influence and the absence of any evidence to suggest that he was wrong had a phenomenal effect on judiciary. I still remember Vaughn Walker, who was one of our students, by the way, who I still am in touch with. He's no longer a judge, so I can talk about him. But he's a very good friend in San Francisco, explained to me that the antitrust law should only be used for price fixing. There was never any justification for blocking a merger. And basically that was Wark's position, I think. So there's a sense in which, even if it's examples, it does affect the climate of public policy, and it does affect whether or not people will take seriously the potential for anti-competitive behavior from mergers. Now, the third thing I want to say, it relates to some work I've been doing more recently in the antitrust area. It's a very, very new thing, and that has to do with the labor market. Every once in a while, I realize you make a mistake. We heard a lovely song about that. And then you try to recover from it. And one of the mistakes I've made historically is, like most labor economists, we never really thought there was any competitive behavior in the labor market. We now know that's just not true. We have plenty of examples even of cooperative behavior, the specific price, naked, I guess it's called by the DOJ, naked wage suppression. And as a result, whenever I was looking at the issue of mergers, it never occurred to me to think about what the effect was on employment or wages. And that was a mistake. I should have been more. I think in some places it's unlikely you'd ever see an effect, but it's probably not difficult to study it in some situations. Now, others it can be difficult. Wages can be even more complicated than prices for trying to figure out how to measure them. But I think that being open to other outcomes is probably something that in the merger retrospective area maybe needs to be rethought a little bit in some areas. So that's my third point. Now the fourth point is kind of a story, and it leads me to what I think is actually someone I was speaking with earlier suggested this policy proposal when I explained a few facts, and it was exactly the idea that I had in my own head. So maybe you'll come to the policy proposal as soon as I give you the facts too. And this has to do with a paper that Dan Hoskin and Matt Weinberg and I wrote about the merger of Maytag and Whirlpool. Some of you know is a problematic merger in some people's minds. We studied that our best we could, econometrically, the effects of that merger on pricing, a lot of different products, a lot of different ways the products are brought into the market. There were quite some puzzles in the paper. For example, no effects on washers, but effects on dryers. It's an example of one I just happened to bring up. Subsequently, because of having written that paper, I actually was involved in the trade case that was just brought in the last 2 years involving the Whirlpool's allegation of dumping by LG and Samsung in the washing machine market. Now, one nice thing about the International Trade Commission is their proceedings are public. So when you write down your testimony or whatever it is, there's no redacting. You just get up and you give it, and everybody can come in and listen. The staff prepares usually a huge document with lots of data that's very public. As a result, I learned a great deal about what was going on in that world, and I want to mention it to you. So that was an example where the merger was approved because of the weapon of foreign competition. There's a theory that we would have it would not be possible for, even though they merged to 80% in some products, it would not be possible for them to increase prices because there'd be foreign competition. Well, as you probably know, there was increase in prices and there was foreign competition. LG and Samsung came in, now have 2/3 of the market. Our recent tariffs are extremely annoying for most economists. We learned from the ITC that there's exactly $20 of labor in a washing machine. There is no labor used to make washing machines. There are 2,000 workers in Ohio, and they make 4 million machines. So they said, as a result of these tariffs, they might increase employment by 200 people. We need 130,000 jobs a month just to keep track with the labor force. 200 people is not even, that's how many people kill themselves with opioids each day. It's a tiny number. Now, the best part about it is, for example, I learned why is it we found this effect on dryers? Well, Whirlpool had a brilliant idea, something you would never think about from theory. They discovered or believed that dryers and washers were complements, and that people would buy them as a group. Up to that time, if you ever bought one, you know that dryers didn't cost as much as washing machines. They cost about half as much to make. ITC documents that, public information. What Whirlpool did was brilliant. They actually raised the price of dryers to be equal to the price of washers. This is more or less what we found in the paper. Why would that's not what you'd expect, but it happened. And LG and Samsung sat back in their office and said, those guys are really smart. We're going to do that too. So now you'll notice if you go anywhere to buy a washer and dryer, they're all the same price. People expect to buy two. Samsung, being in the phone business, of course, then started adding design elements so that you almost have to buy the dryer at the same time as the washer. Otherwise, they won't look right in your, up there, your fancy place. Now, an interesting feature of this is that, so in a way, this whole industry was completely changed as a result of the increased competition from abroad. LG and Samsung are now building factories here. It won't be long before we don't have any American machines of that type. It is true that when the tariffs were enacted a little over a year ago, prices for machines went up by 15% or so. Whirlpool's stock price went way up by a lot, and they said they might hire 200 people. There's a real lesson here, which is if you think that international trade is a discipline device, then I think you have to get a promise from the company involved that they're not going to go to the ITC as soon as they get some competition and have it suppressed. Now, you wouldn't learn that unless you actually followed that merger over a long period of time. So the fourth point I wanted to make was I think there's a good case for an institution having some longer-term memory, very long-term memory, that allows you to understand much more about what the long-term effect was of a decision that nobody would probably today at the DOJ even, there's probably nobody there who was around at the time that it happened. But nevertheless, the idea that competition is disciplined by international trade, it really only works if you have international trade.
So I don't have much enforcement experience, a little bit of consulting experience. So I typically assume that if I'm invited to one of these things, it's on the topic of what kind of findings what kind of research should influence policy. So it's tempting to think of merger retrospectives as a relatively simple exercise, although the people who've done them know better, that there's a merger and you just go out and you look at what happened and you say, well, that's what happened. And I think the important thing to keep in mind is that merger retrospectives are a kind of counterfactual analysis. What you're curious about is what would have happened had the merger not occurred. And of course, since the world is a constantly changing place, that's not immediately evident from what did occur. And so the question is, how do you think about the counterfactual world that would have occurred in the absence of the merger? So in retrospective merger analysis, and in the study of policy effects more generally, one common modeling approach is just a classical difference in difference analysis, which is attempting to set up an appropriate control group that can tell you what would have happened. And the approach controls for, broadly speaking, that you can have some variations, three sets of factors. Observed factors that could include classical kind of demand and cost shifters that you see in your data, some time invariant attributes of markets and or products, and market invariant effects of time. Now, apart from these factors, in a really pure diff-and-diff analysis, the required assumption is that mergers or the effects of mergers in a cross-section are randomly assigned. Now, in the non-merger context, diff and diff became really popular in the context of policy changes, often that were differential in their timing as to when they were enacted. Different states had different policies at different times. And the classic argument was that the timing of these laws, if not the existence of these laws, was really just kind of a random thing, idiosyncratic politics, and that kind of thing. So we might want to think for a minute about whether that argument is plausible in the case of mergers. So, on one hand, the desire to merge is driven by the profitability of private firms who have all kinds of private information about themselves. And on the other hand, the ability to merge is driven in part by regulators who are a consistent national experienced group of regulators who go out of their way to also gain a certain amount of private and sophisticated and sort of qualitative information. So we're not clear that random mergers, even with some fairly rich controls, is the right way to look on things. Now, it might seem that I'm criticizing the analysis, so it's probably a good time to confess that I've done it myself. So, for example, Joel Waldfogel and I wrote, I think what's one of the earlier, but probably not earliest, diff and diff merger retrospectives. We must have been working about the same time you were working on Staples. I think we knew of your work at the time. Our paper was published in the QJE in 2001, and it looks at the effect of mergers on product variety in the radio industry. So I'm proud of that paper. So I think, I don't want to beat up on diff and diffs too much because I really think often it's a really useful thing to do. Now, one important difference with some studies is that we did have an exogenous source of variation in merger policy. And therefore, we could use an instrument, something that moved the probability of a merger in the cross-section of markets. And in particular, the 1996 Telecommunications Act set new higher maximum limits on the number of stations that a single owner could own in a local market, but that was differential. That was cross-sectionally varying across markets. It depended on the total number of stations. Markets with more stations could have more owners. Now, you might worry that the number of stations themselves isn't a very good instrument, but that's very highly correlated with population, for example, with market size. So we were able to use that variation, say, in population, to trace out a differential effect of mergers in the cross-section on top of the diff and diff analysis that controls for other things. Now, Orly talked about, taking advantage of things, right? Well, we wrote the paper because Joel noticed the Communications Act, and many times you don't have that. And I do think that without that kind of exogenous variation, diff and diff gets a little harder. You have to think of some notion of quasi-randomization. So you've controlled for a lot of fixed effects, a lot of product effects, a lot of time effects, but somehow the effects of the merger still have to be quasi-random across different markets or different products or however you want to run your statistical analysis. So that strikes me as strong, but not maybe stronger than a lot of things we do in applied work, and a very useful thing to do. And it's also true that the diff and diff toolkit that's used by labor and public economists has had increasing sophistication in looking for pre-trends and doing placebo effects, kind of in a long hunt for confounding effects and whether you can rule them out. So this used to be a very simple thing to do. Now the papers are very, very long as people try to rule out all the possible confounders that referee 2 has mentioned. So really long now, another recent trend, which I've been more recently involved in, is to apply some of the same kind of identification arguments involving fixed effects and instrumental variables to a more classically economic style supply and demand context. How can we identify supply and demand and the effect of mergers in that context? And, so for example, the demand might be differentiated products or not, might be homogeneous. The supply side might involve imperfect competition. We might or might not be willing to model that. People often criticize this for the reason that there are kind of a lot of moving parts, and it's hard to know where the parameter estimates are coming from. And I think that's actually a pretty good criticism. But I think there's been a move recently, which I want to just briefly elaborate on in this context, that might say we can identify those underlying things more convincingly. In fact, maybe using some of the very kinds of ideas that are used in the diff and diff analysis. So why might we want to do this? I would say first, as a point emphasized by UCLA philosopher and computer scientist Judea Pearl, is a new book. It's got a lot of attention. It's called The Book of Why. So what he argues is what people in general who look at data should be doing is writing down a pretty explicit model. It could be supply and demand for an economist that makes it clear what we mean by causation and counterfactual in the course of trying to figure out what is going on. And his point is that you often need that model to ask why something is happening, not just what has happened. So a lot of merger retrospectives are focused on the what, did prices go up? And you wonder if you can go a little farther and focus on the why, right? Is it close substitutes? Is it synergies? What is the thing on the demand or cost side that's actually going on. So let me just finish with a final thought on that. I think it may be possible actually to combine the insights from the diff and diff and the instrumental variables analysis with this supply side, supply and demand style of model. So for example, let's say that we believe, Orly and Dan, that a particular set of fixed effects in the product level price regressions are sufficient to render the change in market structure a basically quasi-experimental object. That becomes a fantastic instrument for price in the demand function, so that we can actually get out substitution patterns in a very rich way using the policy variation, and I think Orly was getting at this as well too, using the past policy variation to learn about the future underlying fundamentals of the model, right? So if we believe the diff and diff, I actually think it makes the supply and demand analysis actually much more credible, because it gives us this much more credible source of variation to go ahead and do that. So that would be one suggestion for moving forward. And it might create a virtuous circle between these different approaches and might help us to create some synergies between the questions of what and of why.
I'd like to start by thanking the commissioners and the staff, and especially Michael Vita, for inviting me to share my views on this important topic today. It's a pleasure to be here. So this morning I had the opportunity to share my views about what we've learned from a great number of merger retrospectives that have been completed, and also to discuss some of the methodologies. So I'm going to use my opening remarks to answer questions that I rarely answer because they begin with the word should. Should those findings from merger retrospectives influence hospital merger policy? My answer to that is yes, I believe that they should. I understand not everyone believes that. I believe there's enormous potential, and certainly we learned this morning about how much we know because of all of the merger retrospectives that exist. So in these remarks, I want to accomplish three things. I want to explain what I believe the goals of merger retrospectives ought to be, to highlight why the findings can and should influence policy, and to suggest some potentially bold steps to be taken to ensure there are more of them. Okay, so let me start by saying that I believe the goals of a merger retrospective should be to evaluate how an industry is functioning at the time that you undertake the analysis, to describe what value is being created and for whom, and to provide an estimate of how everything would be different in the absence of a merger. The primary goal of a merger retrospective, in my view, should not be to assess whether the enforcement agencies made accurate predictions when they were evaluating the transaction. Okay? To some degree, any disparity between what the agency had predicted and reality will come to light, and that's very useful information that can improve our merger review process. But if evaluating the agency's accuracy were the goal, the primary goal, then I think that those retrospectives would be too backward-looking. We wouldn't necessarily assess outcomes we hadn't been thinking about at the time of performing the review, and it could potentially devolve into some sort of a blame game as to who predicted this and what, why, and I don't actually think that would be particularly productive. So I wouldn't support a proposal to fill out a form of what you believed was going to happen at the time that you did the review, and I think it would also amplify some noise, which is necessary. Necessarily going to happen even if merger enforcement policy is optimal. There's going to be some noise in predictions that we would expect, and we might overemphasize what the prediction was as against what actually happened. So to me, the primary goal is let's try to understand this industry and the impact that the merger has had on it. All right, so second point, if the merger retrospectives indeed use those as the goals, I believe that it's clear they can influence policy. They can help stakeholders, regulators, enforcers figure out what's happening. They can highlight consummated transactions to investigate, inform our screening methods, identify conduct concerns. They can help us understand when merger remedies, whether structural or behavioral, are successful and why. They can help us look at outcomes that wouldn't have been considered at the time of the merger. And last but very very much not least, I think that they can help to deter anti-competitive conduct. Certainly, they would give us the long memory that Dr. Ashenfelter was asking for the agencies to have, and it would be memorialized in a way that hopefully Debbie Feinstein will tell us the courts should find useful. So, third, most bold, is that to suggest that we pilot a default merger review system. So I'm going to try to fix ideas that I believe were suggested also by Commissioner Slaughter. So imagine a policy where all transactions of a certain size, okay, would be evaluated 3 years after closing. The report would be due 6 months later. I can feel the tension in the room. You asked a should question. And the parties would be made aware in advance of the data requests. Compliance would be mandated as part of the merger approval, or the attorneys would come up with some other way to make it binding. The FTC might have to either obtain extra or exercise its subpoena authority to get data from the parties or from other parties if necessary. Okay, there's an out. Okay, if staff did not believe that the merger retrospective was likely to be useful, perhaps because the industry fizzled or there's some kind of shock, then they would write up a little summary of why, and the commission could vote and say we're not going to undertake this merger retrospective. But the fact that and in the case of justice, the AAG could approve the recommendation. But having a rule like that, I think, would avoid issues of selection bias. It could potentially have that deterrence effect, and it would start to create a library of information that so many stakeholders could draw upon. Now, what about the mergers that are smaller? So there are very big ones that we don't dismiss out of hand as just not being interesting to do for a merger retrospective. What about the rest? And there you can imagine some sort of probabilistic decision rule where you have some probability that any given transaction that was approved is investigated, where the weight depends on how big the industry is, how long it's been since a merger retrospective was done in that industry, which maybe for the ones I love, the hospital mergers, would mean no more of those. And something about the volume of transactions in the industry in the last couple of years. So you would try to be selecting with higher probability merger retrospectives that were likelier to add value. And then the total number of retrospectives would have to vary depending on budget. And of course, I would only propose that this be a funded mandate. And I would like to think there'd be bipartisan support. If the number is, you make an estimate of how many this is going to be, and what the staff would be, or source out, commission some of these studies. I think that there could be enormous value in it. And finally, because that's just not enough, I would suggest that we consider adding some retrospectives of transactions that were proposed and that, say, the commission contemplated very seriously or even voted out a complaint and then were abandoned, and study what happened in those cases. That might give us a sense of the over-enforcement margin about which we don't know too much. So I think I'm probably out of time and hopefully not out of goodwill.
Lemur, on behalf of the 600 future members of the Bureau of Economics, we thank you for that.
So a number of the things that Lemur raised are things that we're going to discuss in the question, so I will resist the urge to respond immediately to some of the proposals, other than, yes, saying it would probably require a significantly larger Bureau of Economics, something that I actually, believe it or not, advocated for regularly when I was here in the Bureau of Competition. For just that reason, I felt like we were keeping folks so busy with casework that we didn't have time to do some of the studies we needed, not only retrospectives, but just studies of the industry at large, the impact of, generic entry, that sort of thing, were often very, very valuable in both the conduct and the things. So let me start with, of course, retrospectives can be helpful, and should they be done? Without question. I do think it's important to figure out why are you doing the retrospective. And some of it is what were our predictions and why did we get it wrong. And I don't think it's an issue of the blame game, and I never had the sense that folks felt like that when we did sort of the divestiture retrospectives. But just to say we're going to look at an industry and see how it's functioning and how it would have functioned before the merger, I don't know how you do that without some understanding of how did we think it functioned before the merger and what has changed. So I think that's inevitable. The notion that, of course, it's backward-looking, I mean, that's in the definition of retrospective. That's what it means, is to look back and see what happened. And I think it's also important because you want to basically figure out, what are we trying to figure out here? Is it that our predictions of entry are completely wrong and that we're not good at assessing timelihood, likelihood, and sufficiency and understanding if a particular deal was cleared because folks thought entry was likely? I think it's important to have an understanding of that going in. Now, it's a little tricky because when a commission closes an investigation, we don't always know why the 5 commissioners agreed. The memos aren't, sort of check the box. There will be a whole discussion of issues as to why a particular transaction is not likely to lead to anti-competitive effects. The Bureau of Economics and the Bureau of Competition may or may not agree on why that's happening. They just agree that there's unlikely to be effects. And often it's this holistic view as opposed to one particular thing. But I do think there is some reason to say, why are we asking the question rather than just randomly, hey, let's look at it and see whether or not we got it, whether this market is been changed by the merger, and if so. The resource intensivity is a tremendous issue. I mean, think about the fact that your average merger investigation that involves process takes 6 to 9 months, one merger. With multiple people on it, lawyers and economists, and the notion of doing that regularly. You really have to pick and choose, or you basically have to do wide. You can basically do wide or deep. And in the divestiture study, for instance, we decided to do wide, but only so deep. And basically, we had a very clear question we were answering, which was, did the divestiture buyer actually stay in the market? Was there a business that the divestiture buyer actually maintained? Some rudimentary ideas. Sometimes we got market share. We did not attempt to basically do the deep dive that we would have been able to do on a small handful to basically say, look, can we get the data? Can we look at prices? Can we look at some of those indicia? Because what we were trying to figure out is not the magnitude of any price effect if the divestiture didn't work, but simply, hey, are we creating divestiture buyers that are meaningful competitors in the marketplace? So I think it's really important to go in with a very clear question that you're trying to address, because that is going to drive, again, whether you do deep, whether you do broad, whether you do it industry by industry, as we did, the commission did years ago in hospital mergers, because there was a particular problem. As Commissioner Slaughter said, do you look at vertical mergers because you want to figure out if you've got it wrong there. I think it's really important that you have this understanding so you can figure out how best to use your resources. I do think that even what I call sort of mini retrospectives or retrospectives as we go occur and can be very useful. So when I was first here in the late 1980s, the then bureau director decided to do an informal, non-public gut check kind of retrospective, and it literally involved taking dozens of mergers that had closed without action, but that there was some debate about, and calling customers and saying, so what happened? Worse, better, the same? Just to get a sense of how often were customers saying, you got it completely wrong, you should have blocked that transaction. Interesting to see what happened there, and there was some useful information that came out of it for thinking about not only how to do investigations, but also how to keep files and how to keep that institutional memory going forward. And then finally, I would say, I think that the commission all the time does this kind of retrospective learning because it looks at the same industries over and over and over again, often in the same geographic market. So I can think of one in particular that I thought was really interesting because it's the first merger had happened before I was at the commission, and there was some controversy over whether or not the decision not to take action was the right one. Fast forward, we had another merger in that industry, and in the course of looking at that merger, staff, of course, asked questions about what's happened over time. And much to my fascination, to a one, in great detail, the customers talked about how the previous merger that had been somewhat, debated within the agency and had a lot of scrutiny was absolutely good for them. The promises that the merged parties had made to them had been delivered upon. They basically talked about how they were getting, better deals, better service, across the board. It was good. That was learning that we had, and that continues routinely. So the notion that we always have to do these formal retrospectives, I don't think is the case, because I think there's this organic learning going on as the commission does things. Not to say that formal retrospectives wouldn't also be useful, but I don't want to underestimate the extent to which this kind of learning goes on a daily basis. Thanks.
Okay. Thanks, everyone, for putting this together and for inviting me. It's a pleasure to be here. I think this is actually the first time I've been on a panel in D.C. that was mixed lawyer and economist, and the economists were a majority. So it's like, wow. Debbie, now you know how we usually feel. I had the advantage of going last, because, all kinds of really good points that I didn't even think of. I could say, oh, what Steve said, that's great. And Orly had really good comment. But it also means that, it sounds like that's all I did. And the fact that I have handwritten comments even leads less credibility to claim that I actually have some of my own. Let me just first by asking, answering the question we're put in front of us, should the findings from merger retrospective influence antitrust merger policy? And I think, like several others, I'll give an unequivocal yes. Okay, and maybe I'm done. But I still have to fill 9.5 minutes, so let me go on a little bit. So generally, not just talking about retrospectives, just generally, I think the importance of empirical analysis and of data and antitrust, I think, has been understated, for a long time. I think it's kind of finally coming out. When I was at the DOJ now almost, 5 years ago, that was kind of a big thing that I always sort of would give in speeches and in talks. People ask, well, what's the next wave? I said, well, the next wave is data. Okay, everyone is talking about data except in antitrust, right? You teach in a business school, in our business school, there were statistics courses that no one wanted to take, okay, until they start taking the exact same courses, but instead of calling them statistics, now they're data analytics. Okay, they're packed, door to door, exactly the same material, same teachers, everything the same. Okay, so, I think we should stop calling this antitrust, but, data analytics for competition policy. Okay, so, big data is everywhere except in antitrust, but that's been changing thanks to, a lot of the folks in this room, and I think that's a positive wave. Merger retrospectives are one direction, and I think, the more, the merrier. I actually have been thinking about merger retrospective for much longer, I think, than folks realize. I think when people think about, me and mergers, I'm usually kind of, I feel like, with merger simulation and developing models for that. But actually, very early on in my career, actually in around the same time that, Steve and Orly were talking about, oh, we were doing these retrospectives, I actually put forward a proposal to a private foundation proposing to say, we should game up, gather together with the agencies and start this kind of collaboration, academic, government, to evaluate mergers. We should create this database where we're looking consistently in mergers, getting information from the agencies about what's going on, where should we be focusing our attention, but the agencies are underfunded. How about we have, some of these foundations that would like to fund public policy do that? I wish I saved the referee reports that I got. I wasn't funded, so that just gives you the idea. I wish I saved the referee reports that I got. Maybe I do in one of my old files. But they range from anything like, okay, you're just a first-year assistant professor. Do you really think you're going to pull this off? To, great ideas and so forth. Anyway, it didn't get funded. I put it aside. I guess I wanted to get tenure. Probably should have pursued it a little bit more. Okay, so beyond the simple answer of yes, we should be looking, a little slightly more nuanced answer is looking kind of at the details. And I really want to make 2 points, some of which really overlap with what's been done. One is, how should we be using retrospectives? So that's kind of one point I'd like to discuss. A variety of different things that have been proposed, and then touch a little bit on some of the mythological points that Steve touched about. Maybe not surprisingly, we're going to have somewhat or very similar views here. Okay, so in terms of how to use retrospectives, I think this was discussed in some of the panels earlier this morning, and I would sort of say there's at least 3 different ways to look at. One is to say, let's just evaluate overall policy. Ask a question like, is the marginal merger pro or anti-competitive? Okay, you can ask a question of that sort. So that's kind of one type of use of retrospectives. Another is to improve the tools. We had our kind of second panel of the morning was really all about that. And then finally, a third is the use in either regulatory decision-making or in litigation. Right? When we litigate a merger, should we be looking back, when possible, at what actually happened? So Orly talked a little bit about the Staples case, but there's other cases where there were proper merger retrospectives, not as much as entry and exit analysis, which is basically the same thing, and how have those been used? So let me say a few about each of these one at a time. So on the first goal of kind of trying to evaluate, do we have the line at the right place? I'm less keen on that goal. I mean, not to say that, it's not something worth looking at, but I think there's just a lot of issues that have been brought up before, issues that have to do with selection, of which mergers we're looking at, issues of what is really the marginal merger. Can we really honestly say that we know what that merger is? And there's also a question of, even if so suppose we find that the marginal merger that was approved ends up being anti-competitive. There is a real question as to how that's going to impact actual decisions. Because you could imagine now you're going to make a decision and you could say, well, no, this really isn't the marginal one. Everything that we've seen doesn't really apply to that, right? So it's a little bit of a question. You got to translate into, what does it mean to actual facts on the ground? But to the extent that we are going to do this, and this kind of, again, touches on points that have been made by others, I would focus more on more unique, what I would call, quote unquote, unique situations, whether it's vertical mergers, whether it's kind of other mergers that are, in situations that are a little bit different. Potential competition was mentioned in the morning as another example, and try to look at those situations. And in some sense, just to help us, how should we even start thinking about some of these? I mean, vertical mergers, obviously, we have a clear way of thinking about it, but we have to see are we even in the ballpark in our way of thinking about it. I'm more positive on the second goal, which is the goal of improving our tools and our methods. But really want to make 2 points about this. First, I guess before I even make the 2 points, I mean, this is not easy to do. There's a lot of things going on, a lot of moving parts, and we heard a lot about this in the panel just before lunch. 2 things I want to sort of mention. One is, whenever we're evaluating a tool, we always have to think about what the alternatives are. So I remember in one of the earlier versions of the Hoskin-Weinberg paper, you had the 2 mergers, the artificial maple syrup merger and the oil merger. I think I don't know if this survived actually the final version. You came, okay, merger simulation got one of them right and one didn't, and that's a problem. And I was like, 50% success? Hey, I'll take that. That's good. So there's a bit of a question as to what's the alternative, because in that case, if you actually applied structural analysis, you would have done even worse. Right? So the question is, if you're going to evaluate a method, question is relative to what? You have to think of what the alternative is. So that's point number 1. Point number 2 is looking when we're evaluating the mergers, and you could see that actually a little bit in the panel, the discussion before lunch. A lot of the focus was on the demand side, right? Because we're used to thinking about diversion and cross-price elasticities, and does the random coefficients do better than AIDS, and does it do better than nested logit, and so forth, and so on and so forth. But I actually think where we really need to push the frontier, where we're really missing, is on the supply side. Okay? So I used to give this as a class exercise, actually exactly that paper I would give to the students, say before you go evaluate the methods, just look at the outcomes, take as given what's kind of found from the retrospective. And then make reasonable assumptions on substitution patterns and cost efficiency. What I mean by reasonable is don't suddenly come to me and say, a non-merging party has suddenly become extremely more efficient. or we take, substitution patterns that don't match anything in reality, and say, and tell me a story. Okay, in some sense, I'm telling you, go, make up your demand elasticities and your efficiencies and try to explain what we see in retrospective. And it wasn't impossible, but it was pretty convoluted. Okay, it was pretty hard, and that is consistent. Orly gave an example of the appliances merger. I mean, that's another case that it ends up ex post. Maybe there is a very clear explanation, but one that was completely outside of the realm of what we were thinking about. So the question is, when we look at these retrospectives and then try to match them up to models, we have to ask, what is it that we're missing? I mean, is it that we don't know how to estimate elasticities the right way, or that we just don't have kind of the standard way of thinking, right? If we actually have our typical models that will say you have a smaller part emerging with a larger one, would actually tell you to see more of an effect on the smaller one. And that's a lot of times not what we see. And then finally, the use of in litigation. So this is a place where I actually think it's a little bit underused, both in terms of, being as kind of, if you want, the main effect, but also in terms of, debunking certain things that are brought up. So let me give you an example from the Aetna-Humana case, where I was actually the DOJ's expert. We used a retrospective there. We had a rare opportunity where Aetna, who was purchasing Humana, also purchased a much smaller insurer a few years before. And we can go and look and see what happened. Now, I actually got, before I got on the stand, 2 days earlier, I got the perfect lead into that, where the CEO of Aetna, when talking about efficiencies, said, we're very conservative in efficiencies. Why? Because we use the same model here as we did in the other merger, and in that merger, it ends up the efficiencies were far, far greater. Okay? So guess what? We looked at the merger retrospective, and it ends up that there was a price increase. Okay, so that would be kind of a perfect case where you could say, look, how do we deal with efficiencies? We can look at what happened. So that was my first point. The second point had to do about methodology. I see the sign that time's up. So let me just kind of go through this, basically say, look, a lot of what I have to say is really what Steve said. Let me just add a little bit on the point of saying that when we look at retrospectives, folks think about, diff and diff is the gold standard. And in some ways it is, but we have to realize there are a lot of assumptions built into it. We talked about control, but there's also assumptions about linearity. Do you do it in levels? Do you do it in logs? How do we think about things? And then there's a really big question is how do we interpret the results? And I talked about the example of how we look at them, but also do we look at price? Do we look at quantity? Right? So there's an argument, well, you look at price, but you don't know what happens to quality, and therefore you want to look at quantity because that will give you what happens. Well, there's assumptions built into that. And especially when there's heterogeneity, looking at just price and just quantity is not sufficient. It won't actually give you the whole story. It's very easy to construct examples where prices go up and quantities go up and down, and you can show how welfare could have gone up, could have gone down. We're actually doing that right now in the context of the airline merger. You actually have to dive a little bit deeper. And a lot of times what you basically need to really interpret the results and really understand them, you go back to the fact that you need a model. So let me just conclude by saying, should we use retrospective? Yes, we should. But I think we need to do that kind of very carefully and to really use the results appropriately. Thank you.
Great. Thank you, Aviv. Well, thanks to the panelists. That was a great lead-in and builds very nicely on the discussions that were held in the morning panels. So let me dive in with a couple of questions to sort of follow up on some of the issues raised in those earlier discussions, as well as amplified by the speakers in this session. So as Aviv's comments were a nice lead-in to my first question. So I think what we've heard today is that there are really at least three chief goals of a retrospective merger program. One is to address the really sort of the big question, is policy too strict or too lax, sort of broadly defined? Secondly, how well do our analytical tools work? And three, how can retrospectives help regulatory proceedings, judicial proceedings, that sort of thing? So let's talk a little about, or think about the first question, and especially in light of the discussion that took place in Dan's session about what retrospectives are. It's a whole big collection of case studies, and a very non-randomly selected set of case studies. In the morning session, John Quokka talked about his meta-analysis that covers virtually every study that was done between the early 80s and the time the book was published in 2015. There's like 49 or 50 transactions that were analyzed, horizontal transactions. And there's an amazing amount of concentration in a handful of industries. That's just because that's what the researchers decided to study. So there were 11 petroleum cases, 9 airline cases, 10 cases involving mergers of academic publishers, and another 5 cases involving hospitals. So it's a very small set of industries. So I guess my question for the economists on the panel is, does the fact that the studies are so concentrated on a small number of industries limit the inferences you can draw, especially on the sort of the big overall questions about is merger policy, is it too lenient, too strict? What can we infer?
Do you want me, should I,
You can go first.
are we going to go alphabetically again?
We'll do it this time, and then we'll
Now,
infer.
is that on, or do I have to push a button or something?
I think it's on.
It's on, okay.
Yeah.
Well, the way I always think, here's the framework I would use to think about this issue. The meta-study world, so sometimes that gets a bad name, but basically all that is you collect a bunch of estimates of a parameter that's well-defined. This could be something like, in labor economics, it's the return to schooling. That's the regression of the log of the wage on education level. Here it's a price effect, pretty well defined. There are lots of complexities, but here's the way I think about the meta-study thing, and I even wrote a paper about using this method. You could think of each estimate as having a component which is just sampling error, so that's, we know what the distribution of that's supposed to be, because it's a parameter estimate and they're supposed to be normally distributed at least in the limit. And then there can also be systematic factors. So think of a regression where the retrospective merger effect is a function of some characteristics that are associated with why you would get different effects. And there could be a lot of different reasons for those. They could come from economic theory, or they might come from some other aspects of it. And then there's one further component, which is that if you think of the price effect as a function of these characteristics, there can also be an error, a statistical error in that regression. So that's a framework for breaking down, for controlling for sampling error. That's going to depend on what the standard error is of the estimated coefficient. And then you could, in theory, you can systematically explore what those characteristics are that go with the size of the treatment effects and what's left over that you can't explain. The issue that you're raising is that we can't explore very much of the parameter space because we don't have estimates for a lot of examples that we'd like to have them for. But I still think that if you think of the problem that way, you can always think of it as, okay, I'd like to be able to know what the effect is in some other industry. Well, in order to get that, to figure out what that is, you have to go to the other industry. And that's an organizing framework which a lot of us use when we think about meta-studies. I think it helps, at least for me, to think about how you, so everything is a case study in economics, right? If I think about returns to schooling, there are probably 50,000 estimates of those in every country in the world, many times over. They're not all the same. And in fact, they're not even the same in different, different countries have different, so it's not like everything is the same. There isn't any example really where they're all the same. In fact, where meta-studies really came about from examples of randomized trials. So in the case of randomized trials, we at least know that confounding effects from other variables are lost. We don't have to worry about them. We still have to worry about sampling error, but it doesn't mean that the treatment effect, when you do that, it's going to be the same everywhere. That's basically a point that was made early on by R.A. Fisher. If you think of randomized trials of agricultural products, it depends on where you plant the thing. You're going to have a different treatment effect in one place as opposed to another. So it isn't as if we can't think about this problem, but I concur that we can't go very far in saying things about the parameter space, but at least we could try.
Yeah, so I'll try to be quick. So, obviously it would be better to have more than fewer. And, I think this is where some of these, obviously people are thinking hard about how to get more studies in more places where there's not public data. Second is that, in our field of a broad field of industrial organization, maybe even more so than labor economists, we very much are the people of the detail, the devil's in the detail. So we really do think that the effect of a merger may differ in different industries and under different conditions. And to speak broadly of the policy effect of a merger doesn't go down very well with us, which means we want to think hard about the detail. But I think, maybe Aviv and I and others may come back to the point that this is where I think it helps to have a model and a modeling strategy that gets you back to the whys and not just to the whats. So, we got to diversion ratios through theorists thinking very hard about what the models meant, right? Are the retrospectives showing that that's correct? What are the factors that are generally working across industries and helping us to predict what's going on? If you picked up on the agricultural study, you could sort of throw your hand up and say, well, all soil is different and all elevations are different, and therefore, we need a statistical averaging model or something, I don't know. Or you could have a theory of the effect of sandy soil versus richer soil versus soil with different kinds of nutrients. And that theory could help you then build up a general notion, even though you'd only had 12 plots in different parts of the world. So I think in some sense going up back to the model through the why and back down to things may be helpful.
Thanks for that great question, Mike. So I think this concern about non-random selection of transactions for merger retrospectives is what led me to propose a more random selection strategy. And I'll just say, as much as I'd like BE to be huge, N can be a function of budget. It's just that the selection into it should be formulaic, and then we won't have as much of an issue, which you rightly raised, because as an academic, I think some of the factors that affect what we study include what we find interesting. That explains all those studies on academic journals. What we're worried about, which is why you might think that most merger retrospectives would have a bias toward finding the cases where the agencies in retrospect should have blocked, which only has some value for prospective merger review, where you can get data, the third factor, and then where there's a big N because of large sample properties and also power. And those are not necessarily the factors that you would want to determine merger retrospectives if the objective were to influence your horizontal merger policy. So I'll concur with you and say that the full employment policy for economists to research this is a good one.
Don't want to weigh in on what the economist should be
I
doing?
have a question for Debbie on this, but
Okay.
you can go ahead.
Okay, good. So let me just go quickly on this. So I think in an ideal world, yes, it would be great to have more studies and more parts of the parameter space or more industries or whatever you want to call it. But we live in this world, not in the ideal world. So the question is, does it limit the inference? Yes, we have to proceed with caution. Does that mean that we shouldn't pay any attention to it? Obviously not. We shouldn't be kind of in some sense in any corner, because having some studies is better than having none. But and how we think about this. Actually, the way that Orly sort of posed a problem to me is really the big difference, I think, between how labor economists and how IO economists approach the problem. And actually, Mike Winston and I had a paper about this a few years ago in the Journal of Economic Retrospectives as a comment to a paper by Josh Angrist and co-author. We maybe too much tend to really sort of focus and say, look, each industry, each merger is unique. We can't learn from anything around it because everything is really unique. Okay? I think labor economists, maybe to the other extreme, go and sort of talk about returns to schooling, right? As opposed to, we don't really talk about, what's the effect of a merger, of generic merger. We talk about what's the effect of merger A, merger B, merger C. And, the truth is probably somewhere in the middle. And kind of, you got to have some sort of learning from one situation to the other. And this is, the question is, do you do that learning? There was some mention Jeff mentioned earlier, machine learning. So you basically say, look, let's get all these parameters, let's get a bunch of things that were different across these mergers, and let's have some statistical model that's going to fit something to the surface. That's one approach. Another approach, which I think has more potential, is to go back to the economic model and use that to kind of learn how we should be navigating this space. So I think in many ways I'm back to exactly where Steve was in his earlier comments.
Okay. So my question for Debbie, as you know, as an attorney and as a former enforcer, maybe a future enforcer at some point, you know, how should this literature, you know, how does it or how should it influence case law? How should it influence trial judges who are adjudicating a merger? Does it? Should it? Or appellate courts? What is your experience looking at it from both the prosecutor side and the defense side?
Remember that judges are not thinking about case law. That's sort of a byproduct of what they do. They're trying to make a decision in a particular case, point one. Point two, other people's retrospective studies aren't evidence. An economist can cite to it, but they're not evidence in a case, and the judge can give zero weight to it quite easily. An economist is going to have to say why a study in a different industry is relevant to this particular case, and I think that can often be a very hard burden to show, other than just the notion that some mergers are anti-competitive and some mergers aren't. I don't know how much that gets you. I think if you look potentially at the very same industry, as Professor Carlton did with respect to the Comcast-NBCU transaction, and explain why that didn't have some of the effects that the Justice Department theorized and that were the same as were theorized in the case before it, that may hold some weight. Obviously, the judge mentioned that as one of the factors. Do I think that case would have turned out differently if Professor Carlton did not have that study? I personally, this is just me, think it would have come out the exact same way. It was more corroborative of all of the things that were being said in that case as opposed to an independent. You know, should they have more weight? That makes me nervous, the notion that you would start judging a merger before you based on some other merger where the facts weren't the same, that ought to influence how the judge thinks about a different case with different facts. I think one has to be pretty careful about that. I think the notion, I mean, so that's just particular case. Then case law, bigger picture. Other than hospital mergers, I have a hard time thinking about where retrospectives sort of changed the way courts were thinking about a particular practice. I think that's going to be harder on the merger side to think of something like that. I mean, if you did a study that showed there was never a merger that ever had any efficiencies, yet maybe that would affect case law. I think where it will be more interesting to see whether or not retrospectives affect case laws, you know, in some of the debate about two-sided platform markets, and some people say, we'll be able to show that, you know, the courts have gotten it wrong in thinking about it. I think there it might be somewhat interesting, but I think there's a limit to how much retrospectives can and should be used in individual cases and to affect case law writ large, because judges are making decision about specific cases. I think it's hugely important for the agency internally, but I think once you're before a judge, you're litigating the facts of that case.
Great, thank you. While you guys are speaking, I jotted down a couple of phrases that I heard from you that I think lead to some interesting questions. And one of the phrases I heard from Steve was, figuring out not just what happened, but why. And this sets up a question I was thinking of in the morning session when Lemore was speaking about her studies on cross-market hospital mergers and in thinking about what role, again, should they play in informing FTC enforcement policy. So I hope I'm going to summarize it real quickly, and if I get it wrong, I'm sure you'll correct me. There's a very nice survey or a summary of Lemore's work and the work done by others in this field by 2BE economists Keith Brand and Ted Rosenbaum in the Antitrust Law Journal. But basically, the studies involve mergers of hospitals that are probably not substitutes for the patient at the point of purchase. Geographically separated hospitals. There seems to be pretty robust empirical evidence that those mergers can have substantial adverse effects on prices. So what should that say to the FTC? And a lot of it depends upon, or I guess maybe this is my question. There's different possible theories about what could be driving those results. One possibility is that the mergers change the provider's bargaining sophistication. So an unsophisticated bargainer is acquired by a sophisticated bargainer. They get better, and they get a better price in the next round of negotiations. And then another explanation, I think this is mostly in your paper, Lee-Moore, where for some services sold by the hospitals, they actually might be substitutes for particular patients. And the third is sort of the really novel explanation, which is they're substitutes. The hospitals are substitutes for inclusion in an insurer's network, even if they're not substitutes for patients at the point of service. So there's different possible explanations, and so. Actually, let me go back to Debbie. It's like, so from, so we're if the economists in the Bureau of Economics tell you these are good papers, they're well done, there's no technical flaws with them, the data analysis is done right. How important is it to you to know what the underlying mechanism is that's driving the observed result? How important is that to you, and sort of incorporating that into your enforcement decisions?
Critical. I don't see how I get past a motion to dismiss, which is sort of almost unheard of in a merger case if I can't go in explaining how there's a reduction in competition. An increase in prices as a result of a merger is not a Section 7 violation. I have to show more if I'm a plaintiff in one of those cases. I mean, to me, that's not a lot different than the theory, I think, that was theorized in one of the mergers of, Company A bought Company B. Company A only had one product. It didn't have to worry about its reputation in the market as much, and so it was willing to raise prices in a way that Company B won't. Okay, bad result, but Section 7 case? Wow, I don't think so. I think that would be really, I can't even imagine how you write the complaint that shows that that is a reduction of competition. My personal opinion, that would be extremely difficult to do, but based on conversations I've had with numerous other lawyers, I don't think that's a minority view. So understanding why it is that actually is the result of a reduction in competition for what, I think is really important. So I do think you have to understand the theory to be able to write the complaint that passes muster, and to be able to explain to a court why this merger, as opposed to another merger that might take providers in totally different places, isn't problematic.
So my question for the economist, and obviously Lee-Moore, I'll let you go first, is, so to the extent that it is important to understand the mechanism that's driving the results, is it a reasonable expectation to expect you or anybody, any of us, to be able to determine that? And, the typical retrospective, as Steve said, asks what, not why. Is that asking too much of our methods and our data, or is that something we?
It may ultimately be asking too much of the data, but it's absolutely not asking too much to try. So in our paper, apologies to those who were here this morning, but it was motivated by being here and seeing the success of the horizontal hospital merger retrospective, and at the same time hearing about the fanning out of hospital systems across the country and concerns raised by insurers that they were able to negotiate higher prices. Section 7 is not that long, and I know in it does not include if transaction leads to price increases, then it's a violation. It's a lessening of competition. And so it's very important that in doing that analysis, we developed a model that we think leads to an actionable antitrust offense if you can find enough supporting evidence of it. So let me try to be clear about what it is and what is the market. It's basically if there are hospitals that are not competing for the same patients, they're potentially in different geographic markets, but if there is an insurer that is offering a bundled product of hospitals and other services to employers who value hospitals in these markets, probably because they have employees who are commuting from both places, or they have employees in multiple sites. So if there is a common customer, then the combination of those entities could increase their bargaining leverage when it comes to negotiating for inclusion in the insurer's network. Okay, so the presence of common customers and a common intermediary that is negotiating with these players can lead to a price increase. Now then, the question will be if empirically, when we find, as we did, that these transactions tend to lead to increases in price when they occur in the same state where we think common customers are likelier than when they occur across states, whether that is sufficient evidence of that mechanism or you can come up with an alternative, I think that's for us to discuss and/or our referees to debate, although we got published, but we had those debates.
Yeah, thank you,
So I think, it's a great question, and I think that's exactly, one of the, if you want, the weaknesses of just a pure retrospective without kind of follow up with an additional study. I used to, I would, whenever I'd visit various agencies, I'd actually give them an example. I'd have to talk a lot about bargaining models, because actually in that context it comes up a lot more. And I would give them an example of saying, suppose, you have a national coffee chain, okay, with a green logo, let's just assume, buys a local coffee shop. And they say, we're going to increase the price. Why? Because we have regional pricing, and we believe a cappuccino should be $3.50 or $4, whatever it is now. And, the local mom and pop shop didn't think that way. And this is a fact. This is established, it's stipulated to, it's not in dispute. Would you block the merger? Right? And what you get is, I think, exactly the response. Debbie didn't respond to that question, but gave almost an identical hypothetical. I would say 90% of enforcers, this is around the world, would say no. And usually the 10% are young economists that have only been there 1 or 2 years and say, wait a second, prices have gone up. It's like, the most comical was actually meeting with the chief economist team at the European Commission, where 1 or 2 of the economists, the young economists, swung up, and the rest of the team in that, went up and like, no, you guys don't know what you're talking about. That's not what we do here. That's not the case. So that's, so I really think you need to go to it. And the problem is not just with retrospectives. Even when you go to models beyond our kind of simple, differentiated products models, you have to start agreeing what is a loss of competition. Okay, so if you look in the case of bargaining models, you might want to separate between leverage and power, right? In the sense that I have better leverage because of the merger. I would personally argue that's probably loss of competition, versus I now have more power in the sense that I have better lawyers, that I didn't increase the size of the pie, I'm just getting a larger part of it, because now I can afford to hire Debbie, and Debbie's a much better lawyer than what I had before, okay? That, I would say, that's a little bit more like the managerial ability, like the pricing policy. But not everyone would agree, and I think that's kind of the frontier of understanding not just what happened, but then figuring out what's our lines, what's a loss of competition if it's not an increase in prices.
Can I respond factually, just in the situation of cross-market hospital mergers? I just want to point out that our study focuses on the acquirers, not the targets. So what you're pointing out is certainly very relevant. And we also have a treatment group that is likelier to have common customers as against a treatment group that was similarly exposed to a merger, had made a transaction and purchased hospital outside. So I would say those 2 excellent examples pertain to the question, but the evidence that exists in this industry is, I think, robust to them.
Worley or Steve, would you like, do you have anything to weigh in on?
Can I ask a question of Limor, and then you can, I don't have any comment, but I do have a comment, which is, we all know there are effects from mergers, and we can get the pre and the post price and take the percentage change, and we can call that the effect of the merger, and there's no reason why we shouldn't study it and expect to be able to predict differences in it, in fact, based on economics. I will say that as a response to Aviv's comment. But I wanted to ask Limor a question. So would you go so far with your proposal as to suggest that people register their studies before they do retrospective? See, one of the, that's what they're doing in development.
Like clinical trials, right.
Well, development economics,
See, it's
too.
good to put something out there so that we can have some debate.
Write down what you're going to do.
It's
That would be part of your proposal?
only about half of the reason that I proposed was to have this fun discussion in the afternoon on a Friday.
Everybody understands it.
I do understand it. So what you've asked is, wouldn't it seem to be appropriate to register the existence of a study? And so many academics will do something, not find anything, and say that nobody wants to publish that, and or not, because it's not only a 0, it may not be a precisely estimated 0, which you really can't publish. So I would say yes.
I think your proposal is definitely going to get you in trouble.
But you're having a good time,
You're
right?
only in trouble with me.
Just one quick thing, which is, I think, two interesting points to your question. I hadn't thought of the first one, and people spent a lot of time on it. It's interesting. One thing is, if in the absence of a mechanism, are you sure that the effect is competition, right? The other thing is, in the absence of a mechanism, do you even believe the result, right? So it's very common, again, among our public labor colleagues, someone publishes a paper, they say, we lowered the cost of going to college, fewer people went to college. And people say, in the absence of a mechanism, I actually just don't believe that result. I just think it's a weird outlier, right? It's just some, I'm not saying you didn't do the study right, I'm just saying it's some weird, the T-stat, 1 in 20 times, it's, significant. And so I think one thing is particularly for a surprising result, you want at least an hypothesized plausible mechanism, right, before you believe it at all, which I think you provide. I'm not talking about your study, right? You followed up, you provided it, right? And then I think even better, which you also just mentioned, is some actual evidence in favor of that exact mechanism, right? But I think there's sort of a credibility ladder, right, when you get the surprising result of
Steve,
is
I've
there a
been
possible
asked to ask
mechanism?
you to speak into the mic.
Sorry, yes. I'm leaning back too far.
drifted
Usually I'm
away.
so loud that there's no chance that somebody can't
We
hear me.
drifted away.
Yeah, so I think there's this credibility ladder of, if it's a surprising result, is there any plausible mechanism, and then is there any evidence for that mechanism?
Okay. I may want to return to this point in a little bit, and I might have a question for Debbie on it, because this sort of relates to the proposal that I see Dennis Carlton's in the audience. He's on the next panel. He's made some suggestions along the lines that we've been talking about, and maybe he's going to talk about that. Maybe he's not, but let me put that aside just for the moment, because we have a question here from the audience that I think it's a very good one, and I think I'd like to hear the panel's thoughts on it. So the question is, Commissioner Slaughter mentioned acquisitions of new potential nascent competitor firms that might develop into competitive threats in the future. Facebook, Instagram being an example that's frequently talked about as something that might be a good example of that. So Facebook acquired Instagram when Instagram was quite small, but there's an argument that had that merger been prevented, Instagram may have developed into a social media platform that would have presented some kind of important degree of competition for Facebook and other platforms. So the question is it even possible to do a retrospective study on a case like this? What would the control be? So who wants to go first? Aviv, why don't you go first? Here at the no, excuse me, you go first.
I'm afraid I don't see how you can do any. I mean, this is people speculate about this, but without some. I think this is an example where you have to use something anecdotal. In fact, I guess if Steve didn't exclude, and I certainly wouldn't, anecdotal evidence for mechanisms, then you might find some way to do that. But I don't see how a quantitative method, I mean, people propose ideas like that all the time. I don't know how you could actually establish that using what we normally think of as economic methods.
Yeah, I think it'd be incredibly tough to think of that in a retrospective context. I do think there are cases where we're going to have to rely on, let's make it a little stronger than anecdote, a good anecdote, deep institutional knowledge, and a consistent theoretical framework that has perhaps proved itself in other dimensions to make us think about what's the source of dominance here, what do we know about it, what do we think about it in the deepest way, and what would happen.
Ned.
What?
Oh,
What?
nothing, Ned.
Nothing?
So I think the easy thing to say is I agree, and I do agree with that.
Yeah.
But there is one version that might actually be somewhat workable. I mean, somewhat. So suppose that what we say is the goal not to say what would have happened but for the acquisition, but we want to say there was a promise of you acquire this up-and-coming firm, and we say, no, we're actually going to develop them. We're going to bring them up. We're going to let them be, bigger and greater and, a lot better than they are now. That you can go back and check. So this goes a little bit back to, do you want to compare to a retrospective? Do you want to compare relative to some promise or prediction or some discussion that was happened as part of the approval? So, in that case, what you're looking for is relative to a promise. That's how you get the quote-unquote but-for world.
Yeah, just two anecdotal points on that. I read an interesting article recently where the Instagram founders all said they were horrified by what Instagram had become because they always imagined it to be this small little boutique-y kind of place, and in fact it had become this big giant. So it was interesting that that wasn't the goal, right? I mean, and so I think the best you can do as enforcers is look at what the documents say at the time. And the irony is we wouldn't be talking about Facebook, Instagram if Facebook had taken Instagram and put it in the drawer and never done anything with it again, because we would say then it hadn't squashed the I mean, there's sort of, you're sort of in these nascent industries caught either way. If you develop it, you get told, well, if you hadn't bought it, it would have developed like that organically. If you stick it in a drawer, it's evidence that, oh, you squashed it. So I'm not sure how you do a retrospective on that either way, because I'm not sure even what you're looking for sometimes in those kinds of cases.
Let me ask sort of a follow-up, sort of that's a bit related. A lot of the industries that are important and the subject of public policy debate are industries that are basically the price to the consumer is zero, or the explicit monetary price to the consumer. But those are important industries, and there are concerns about the degree of competition in those markets. How might one do a retrospective study of a merger, say, between two firms like that, where it's they earn their revenues from advertising or something like that, but the services they provide to consumers are also important. How should we think about that? And if we were to do a study of a merger like that, what kinds of questions should we be asking, and how could we do the analysis?
Well, here I think Aviv should start.
Okay, thank you, Orly.
I think that was
Second time today that we agreed. So first, let me just point out, this is not completely a new problem. Everyone talks about, products are free and it's a whole new world. There's this thing that now no one watches because we watch all video on our TV, on our phone, but a thing called the TV that's been around for quite a while that exactly had this, model that you get eyeballs by offering free programming and then you sell advertising, right? I mean, substitute programming for YouTube, for cat videos, and we're going to Google, right? I mean, that's, so it's not completely new, and obviously you'd want to look at different things, but you could imagine looking at what happens to the price of advertising, if you were doing this in the context of TV. You could imagine what would happen to the quality of programming, although please don't ask me how we're going to measure the quality of a cat video.
I was going to ask you that.
But that is kind of, I think, the idea of, this is, yes, these are newish kind of things, but they've been around and been looking and evaluating mergers in that for quite a while. In industries like that, when I say that. Industry like that for quite a while, so.
I'll add some other potential outcomes. We certainly investigate non-price outcomes all the time, on-time performance. In the case of some, I guess, as Commissioner Slaughter would call them, technology-intensive industries, you can imagine both the ad intensity and the extent of data breaches, the degree of privacy protection. And in some of these cases, using output as a marker might be a useful way to try to explore, right? If they burden me with too many flashing things and so I stop consuming online news, then some transaction that may have lessened competition and provision of that, even if the monetary price was free, could be interpreted as having been anti-competitive due to the output reduction.
I would give a pitch from some of my theory colleagues' work on this, actually. Dirk Bergman and his co-author Bonatti, I think, have some nice theory papers talking about what the data markup is in these industries, and it's exactly this kind of bartered thing where people give you something of value, you give them your data, and they sell your data. And there's a really clear markup there, which is what they get for your data versus the value of what they give back. So I think Aviv is right, which is in the sense that you could easily, if you had subpoenas and other things, think about how much they're getting for the data that they're collecting. And then you could, of course, look at the cost at the margin of what they're providing back to you. Probably the theory says it should be the value of what they're providing back to you, which gets at this quality issue. But for example, if you think the quality hasn't gone up much and the advertising price went up a lot, I think you could conclude that the markup went up.
Well, I'll just add that when you think about TV is not a bad example. Radio is probably a better one before that, where you don't even have to look at it. These are industries where we've typically measured their value by their total box office. And the box office, of course, is defined as the combination of anything you pay directly plus whatever is generated in advertising revenue. So the idea it's free is that's a little bit nutty. Movies have now typically both ads as well as a ticket price. So I think it is right. You can think about what the total revenues are. Whether you could ever challenge anything as anti-competitive because of the fact that they managed to get their box office up in the law, I'm not too sure. And maybe Debbie can respond to that, but I think it might be a difficult case to make.
So think about other sort of formidable problems that you face addressing important policy issues, via the route of a retrospective. In a lot of markets, what we're really concerned with is not so much static pricing behavior, but we're concerned about things like innovation. Law and the FTC and the DOJ bring a lot of cases that are based on a theory that the merger will reduce incentives to innovate. Innovation competition is important. Is that something that's really amenable to study using the kinds of data and methods that we're likely to have available to us? I mean, how does one measure innovation? How does one find a satisfactory control market against which to benchmark the potential loss or gain in innovation? So, anybody want to take a crack at that? Aviv?
Sure.
Just to mention a name randomly.
When the going gets tough, send it to Aviv.
Yeah, that's right.
I think, look, in terms of importance of the question, understanding the effects of merger on innovations, I think that's extremely important. I think there is a certain sense in which what we all do is we kind of, always looking under the lamppost because that's where we have the data and that's where we have the models, that's where we know what to do. But innovation might be in the long run really the key thing. That being said, it's very, very hard because, innovation almost by definition takes a long time to see the effects, right? So if you're going to do a merger retrospective and say, oh, let's look 10 years later, good luck convincing anyone that you really got a causal effect of the merger. And again, unless you were able to run some social experiment and take two industries, identical industries, and, have a merger in one and not in the other. So I think that's just a long-winded way of sort of saying it's a great question. I don't know that I have the answer to it.
Okay, so let me try.
Yeah.
I think I'm not saying I'll succeed. I think the hardest question is just measuring innovation, right? And academics do this by things like patents, indirectly through R&D expenditures, other measures, and they're heavily criticized. Then again, a lot of our price measures turn out to be not so good as we claim when we use them. I think once you have an innovation measure, then we're just back in the whole debate that we've had before. I agree, maybe the lags are a little longer, but I talked about my merger retrospective with Joel was about product variety, not about price. So the question is, we had to take a stand on measuring product variety. Having done that, we could do the same technique. I think the European Commission, in looking at innovation cases, has on the theoretical side taken a stance that's very similar to what they would take on price, that a merger has diversion effects and market expansion effects. And that's not that different than lowering your price effects, where we talk about diversion versus growing the market. And I think if you could, I don't think anybody's done it, I think if you could get a good measure of innovation, you could put it in some of our existing frameworks. It's an interesting challenge for somebody young.
Orly, did you want it?
Well, I just want, the other thing I'd add to that, probably Limor could have more to say about this. It seems medicine is one of the areas where there's a deep concern about innovation. I'm thinking of the pharmaceuticals. Mm-hmm. And there might be better opportunities to measure things there. I'm sure it's an issue in the potential for pharmaceutical mergers. And there might be some way of quantifying a little more rigorously than sometimes occurs with just patents in that field. But you might want to say something more.
Yeah, no, I do. Thanks for the lead-in. I'll start out by repeating that, first of all, you ask hard questions. It's very difficult to know what the counterfactual is to try to predict what innovation we might have enjoyed in the absence of a transaction. And if I wanted to do that, I would surely not go to a group of economists first to ask That was a joke. I do thank you. I think the methods. But we're laughing now. I do think the methods are very conducive to looking at some modes of innovation like product variety. I will say that in healthcare, as Dr. Ashenfelter suggested, there have been some pretty interesting studies looking at drug development, most recently by one of Steve's colleagues, Florian Ederer and co-authors, who found that when pharmaceutical companies acquired drugs in early stages of development below reporting thresholds, that they were much likelier to kill them if they already had something like that in development. So there's some evidence in healthcare. It's also possible to use models of technology diffusion and adoption to try to predict the but-for world, which has been tried in terms of healthcare adoption of healthcare technologies in more versus less competitive markets.
Okay, well, actually, we're down to like a minute and a half. I don't think there's. I have another question from the audience, but it's a pretty detailed one. I don't think we have the time to get into. So I'm just going to say thank you to our great panel. It's been a great discussion, and I think we're lucky to have had all you guys here today. Thanks very much.
Thanks again to you.
breaks are the best part about these hearings, but we need to get started, especially since Marty has a quick connection and is going to have to leave us right after this hearing. So this is the final panel, and the title of the panel is, you can tell the BE did not name these panels because this panel also has the word should in it. What should the FTC's retrospective program be over the next decade? BE did, of course, have enough pull to once again have 4 economists and 1 lawyer, not counting myself. So once again, we have another great panel, and I'm going in reverse alphabetical order, just to be contrarian. So up first, we'll have Nancy Rose from MIT, Department of Economics. She was also, everybody on this panel has agency experience. She was the DAG, is that what they call it? DAG at Justice. After Nancy, we'll have John Kwoka, who was on a panel this morning from Northeastern University. Right in the middle, we have the one and only Bill Kovacic, my former colleague. I guess it's unfair to call him a lawyer because he was my colleague at George Mason, and everybody at George Mason's an economist, at least in
We are all economists, Bruce,
yes.
yes.
Next to him is, Bill is at George Washington University. Next to him is Marty Gaynor, who used to have my job. He's from Carnegie Mellon University. And at the end is Dennis Carlton from the University of Chicago, Booth School of Business, who was also the DAG at Justice. So I'm looking forward to the discussion, and Nancy.
So I don't have slides. Do you want me up there nonetheless?
No, you can sit.
Is that okay with your video? Okay, so thank you for the opportunity to share my perspectives on what I think are a very important set of topics, and a topic set where enforcement and academia perhaps most productively intersect and collaborate, and that's a space I feel I occupy, or privileged to occupy. You've heard a lot today about what we've learned from retrospectives, how to design and execute them, and what their value can be to enforcers. So I'm expecting during the Q&A, I'll weigh in more on some of those questions, which were in this final panel set of topics. But I think my highest value might be to start with questions and answers that haven't been discussed at length by panelists. So I want to start with the last question that was on the set that Dan and Bruce circulated for this panel. Should the FTC devote more resources to retrospectives, even at the cost of current enforcement? And I was delighted to see Commissioner Slaughter be so passionate in her defense of the need for more resources. This goes to what I feel is the most significant and yet still largely invisible message in the ongoing debate over competition policy, which is that antitrust enforcement in the United States is chronically and substantially underfunded. For years, the appropriation requests have been modest in their increases. Oversight hearings and interactions with the Hill have too often featured the mantra, when business picks up, our talented and hardworking staff just do more with less. I will say, I think the career staff at both the FTC and the DOJ Antitrust Division are among the most dedicated, highly skilled, and hardest working professionals. It was my great privilege to work with a number of them at DOJ, and I know that colleagues who've worked at the FTC feel the same way. They deserve our greatest appreciation and applause, and not just from those of us who work in antitrust policy, but from the entire American public, on whose behalf they tirelessly work. But there is a limit to the number of hours in a day and the number of days in a week, and the well below market compensation for the lawyers and economists who work in the agencies, which is another significant problem, isn't sufficient to demand that staff give up all rights to leave their buildings, occasionally see their families, or catch up on sleep. And so I think it's inevitable that if we're asking agencies to reflect on the effectiveness of their decision-making through programs like retrospective programs, it's going to come out of someplace else, and I fear that given the ongoing intensity of the merger wave, that's going to come out of enforcement. We are amid an ongoing, sustained, what's been called by some tsunami of mergers. Each year, there are thousands of mergers noticed to the agencies and thousands more below the HSR thresholds that work by Thomas Woolman at the University of Chicago suggest skate through to consummation with practically no probability of review or action, the occasional consummated merger enforcement action notwithstanding. The dollar volume of mergers is at historic levels, and that suggests that there are a lot of mega mergers competing for enforcement resources. In addition, litigation costs continue to climb, both for challenging mergers or bringing Section 2 actions, especially as parties with especially deep pockets escalate litigation defenses, correctly calculating that even adding some tens of millions of dollars in antitrust litigation costs would be just rounding error in their merger financing. So it's inconceivable, and finally, because I would say it's inconceivable to me that there are not at least some counsel that are advising parties that a good time to bring marginal mergers forward is when the agencies are stretched thin by major investigations or multiple litigations. So I was interested to hear the statistics that Commissioner Slaughter shared after lunch. I recently did a back of envelope for the Antitrust Division just to understand kind of the nature of this problem, setting the number of mergers and the Antitrust Division dollar budget in 1985 to 1, and then carrying it forward in real dollars and number of merger terms. And I expected to find that mergers increased faster than the budgets, but I was frankly a little stunned by what I found. So total U.S. mergers are at 5 to 7 times the level in 1985, and the real dollar budget for the Antitrust Division peaked at less than twice the 1985 level in the early 2000s. It remained roughly flat and has even declined slightly in recent years. So if Congress and the American people care about antitrust enforcement, and there's every indication that, that many of them do, we need more resources, first for enforcement, and then secondly for programs like the retrospectives that we're talking about. So now let me go to the retrospectives and say a few things about that. I think one way in the short to medium term to help with both of those objectives is to perhaps do a little bit more outsourcing or collaborative work of retrospective activity with academics. One way to foster those collaborations would be to offer access to data to academics, particularly data that would not otherwise be readily available. So I'd encourage the agencies to think about how to write explicit data production requirements into future merger settlements. That's one way to perhaps give you a stream of data into the future. And I would say they should do that even with structural divestitures, because we don't really have a great sense for the impact of many of those. The FTC's noteworthy merger remedies retrospectives notwithstanding. That's only part of the data that you'd want to analyze the effects of mergers ex post, but at least it gets us started there. And I think that that then in terms of the collaboration, there are a lot of models that one could use to both respect the confidentiality requirements that are likely to come with data collected in that way, and also to engage academics. So just to mention a couple, you could think about the Bureau of Census sworn employee model. I think something similar to that is used by the Consumer Financial Protection Bureau to bring academics in and work with their data on questions of mutual interest. You might be able to attract early stage doctoral students who are often looking for interesting research questions and data that others haven't worked over. I think agencies could probably increase programs for visiting academics, encouraging them to visit to develop retrospective analyses that might be able then to be continued post-visit. You'd need to have that be written into it, given the depressingly long publication lags that now exist in economics journals. And here's a, maybe silly, but maybe not idea. Since academics seem to like recognition, perhaps the FTC could add a competition for Best Merger Retrospective Study of the Year and award that at its annual, very successful Applied Microeconomics Research Conference as a way of recognizing and rewarding that kind of work. Those are just some ideas of low-hanging fruit that aren't going to get us to where we ought to be, but at least might start us along the way. So now that we've solved the problem of how we're going to encourage and facilitate more merger retrospective analyses, where should that work focus? I would say the top priority should be to identify where our models of likely competitive effects go awry and why. So here are a few candidates. First, do we focus on too narrow product overlaps that aren't really where the competitive harms lie? So Lee Moore's discussion of these non-geographically contiguous hospital mergers are an example of that. I would say the Comcast Time Warner Cable case that I worked on at the DOJ was another example of that. Maybe data creation in tech acquisitions is an example. Second, we should look at analyses that might miss what I might call portfolio effects. Lee Moore's could be an example of that. Could be portfolios of unrelated drugs, oil field services, which is a merger that I worked on at DOJ, sort of examples where it's not just the narrow product market overlaps that are important, but there's something about the broader portfolios that the two companies have that affect competition. Third would be, do we fail to capture potential competition problems? I think this is understudied in academia and I think underappreciated in the agencies. I think it's also extraordinarily difficult given case law, but that might benefit from more analysis, and particularly if we could show through retrospective analysis why that area might merit more attention. And then finally, I would say, I think there may be an unwarranted focus by academics and antitrust practitioners, here I'm about to say something fairly heretical, on unilateral effects. So I know that was seen as a great advance when we moved to that in the horizontal merger guidelines, but as has been discussed earlier, we often are thinking about unilateral effects models, either differentiated Bertrand competition or maybe Cournot competition, depending on the nature of the product. And we generally assume once unilateral, always unilateral. I don't think we understand as an economics profession kind of what mediates the transition from one form of competition to another, that is to say from non-cooperative to cooperative. And I don't think we understand if those models are rich enough to capture what's going on in markets. And so trying to understand better where that kind of focus might lead us astray. Thanks.
Right. Thank you, Nancy. All right, John.
Thanks, Bruce. Between the last panel and Nancy's comments, there's very little for me to add. I'm much in agreement with everything that Nancy has said. The previous panel came to one overriding conclusion, that is more merger retrospectives are good. There was a certain fragmentation of views after that. So let me return to some degree to what I said earlier this morning about the different purposes of different types of merger retrospectives. In contrast to some of the discussion earlier, I do think that examining single mergers does have considerable value. And it is because I do think that the process of examination on the part of the agency for in cases where the outcome was different from what was predicted are incredibly important in the process of continuous improvement of the analysis within the agencies. I think that there have been examples where this has already proven to be the case, where the agencies have examined past decision-making and investigatory strategies and have revised accordingly. This has also been true elsewhere. To shift focus to a side discussion that occurred about the tech sector, examining the way that the EU looked at the Instagram and WhatsApp acquisitions by Facebook is actually instructive. Because in the Instagram, they of course put much more on the record, and the issues are slightly different and the analysis is different there than here. Be that as it may, if you were to read the entire record of both of those as published by DG Comp, you'll see that in the second of those acquisitions, there was a much more sophisticated understanding of some of the risks of approving the merger. They approved it anyway, but nonetheless, you do see that the internal processes of the agency had learned something from the first go-round and applied it more rigorously the second time through. That occurs within the FTC and within DOJ for sure. That is to say, the repetitive mergers and acquisitions within individual industries, the resident expertise within the agencies is brought to bear repeatedly on these issues, and there is a considerable improvement in the techniques that they apply. So I do believe that this is, and I might also add that when we talk about merger retrospectives done for that purpose, no one is talking about academically publishable quality mergers. In some instances, these can be done quite readily. I served as consultant to the state AGs on a series of airline mergers. Data is publicly available. We had the data cleaned. We had the software ready. The next merger could be analyzed fairly quickly after the 1 or 2 or 3 preceding ones had been reviewed. So in some instances, it's quite straightforward. In other instances, of course, it's devilishly hard, but I think it's an exaggeration to think that this is an intractable problem in general. The other comment I'd like to make is with regard to meta-analysis. I mean, it's been pointed out more than once that the meta-analysis that I did is heavily concentrated in a certain number of industries, 16 by actual count, and that there's a disproportionate sampling within 3 or 4 sectors. However, the results are insensitive to the fact that there are multiple mergers within hospitals and academic journals and airlines, and the simple strategy, which I've reported on, to determine that is simply to take an average of the results for all, say, hospital mergers, and rather than taking the weighted average, which is to take every one of them separately, and you get very much the same results. And so the result of the happenstance of the sampling that was done in those mergers is not dispositive. The question is, of course, the deeper question is, to what end is meta-analysis appropriate? My work was not to develop a scorecard on the agencies. My efforts were to try to draw inferences that would allow better enforcement strategies in future mergers, and certainly not to, as my book points out, is not to simply say challenge more mergers. The issue is to try to look at those at the margin to see what it is that might have been decided or pursued differently. Which ones are at the margin? Well, there are ways of determining that as well. And I don't want to spend all my time here today talking about that, but it is quite possible to determine the ones that were unambiguously anti-competitive and to look at some of the structural characteristics of those. The other uses of meta-analysis, I've put those to 2 other uses. One of the uses was to examine whether stock market event studies are good predictors. And I've published a paper that shows, based on the actual merger retrospectives, the stock market event studies, which were a fad some time ago, in fact, very poor predictors of the actual outcomes. I've published another paper which uses, again, the same database of merger retrospectives that examines whether structural characteristics of the sort that are in the horizontal merger guidelines, the levels and changes in HHI or numbers of significant competitors, whether those essentially structural characteristics are good predictors. And the answer is yes, they are. They make very few false positives if one chooses them correctly. So those are inferences about broader policy that I think are helpful, and those cannot be addressed by looking at 1 or 2 or any single small number of mergers. I did have other recommendations, but again, most of these have been covered. Nancy has been eloquent, as did Commissioner Slaughter early, about the need for resources. There seems to be bipartisan support on the Hill for more competition output, but it's not clear that there's bipartisan support for more input into the process. 2 years ago, then Congressman Keith Ellison did introduce into Congress a so-called merger retrospectives bill of 2017, I guess it was, which provided for the agencies to, in fact, do a certain small number of merger retrospectives each year. There were provisions in there for how they were to be selected, who might review the selection process, et cetera, and an increase in the budget, specifically earmarked for that purpose. The point of that was that there is, in fact, some appreciation of the constraint imposed by current budgetary issues within the agency. The idea of having the agencies required not to do 10 or 50 of these per year, but to do at least a handful, reflects a similar policy in the UK, where, as many of you know, and I guess Bill Kovacic knows more about this than I, but I think there now is a requirement that they do a couple of these per year on the basis of matters that they've reviewed. Dan Hoskin and I sat on a evaluation panel 3 years ago at the OECD that looked at both the UK and also a couple other countries' efforts to look back on their policies and to evaluate how effective and how accurate their decision-making had been. Those are all, it seems to me, well-taken initiatives, and they all, it seems to me, feed directly into the need for something of the same sort within DOJ and the FTC. How might the data be collected? So the FTC has 6B authority, and that is a mechanism for collecting data. But it's also seems to me possible that both agencies can, as a regular practice, require production of data from parties that have filed mergers that go through some investigatory process and consent order or agreement with clearance or remedy or consent with the agencies. In fact, without changing the HSR law, it seems to me that could be, I'm not the lawyer here, but arguably it might be implemented to require all parties filing HSR to do so might require statutory changes. But in any case, a significant fraction of mergers would end up being required to produce data that could be evaluated subsequent to a merger or a remedy. That, of course, might have a therapeutic effect on the parties as well, but it certainly would provide the agencies with the raw material to conduct lookbacks and to see whether, once again, the parties' representations about price or, for that matter, efficiencies, and whether the agency's decisions with respect to how to resolve these mergers, in fact, were borne out. So I think all of those are strategies we're thinking about in order to implement this. And again, I heartily endorse Nancy's very good suggestions for how to finesse some of the resource constraints, but certainly to think about how to institute a comprehensive strategy for merger retrospectives in the not-too-distant future. Thank you.
John? Bill?
Thank you, Bruce. Thanks to your colleagues in the Bureau of Economics and indeed to the Commission for the chance to participate in this superb day of discussion. It's really appropriate that the FTC convenes an event on this topic, beginning with the FTC's first evaluations of past vertical restraints cases and the Xerox case in the late 1970s to the present. The Commission is the reason that there's global awareness among competition authorities that some investment in evaluation is crucial to do two things. To answer the basic question, how do we know it's working? And second, to know how do we do it better the next time? And there is, I think, a general global acceptance of the idea that this is crucial not just to effectiveness, but to legitimacy and accountability as well. And that all started here. No other agency had a greater impact on shaping those norms. I want to talk about 4 specific suggestions, a bit about building an analytical baseline for doing the evaluations, to talk about big antitrust data, which the agencies have, which several colleagues have mentioned today, to talk a little bit about how to deal with resource constraints, and I agree, a boost to the budget would help, but I won't really believe the sincerity of the Congress until they relax the caps on salaries where they are now. If they're not willing to put the FTC on a plane, at least with the Federal Reserve Board or the CFPB, and to increase salaries to match the higher paid agencies, or God forbid, to go even halfway to market rates in some instances, I won't believe it. It's not a matter of having more bodies. It's a matter of having good bodies, and you don't get them and keep them unless you're willing to pay for them. So I regard so much of the legislative debate about resources as being an organized hypocrisy. Until we see the resources put with the people that we need, we're just churning. We're not going to do a better job. The analytical baseline, big data, resources, and institutional support, how to sustain things over time. How to build the baseline. I see a great value in documenting, and I think this is a low-cost step, the assumptions and priors that went into the formulation of the decision to prosecute or not to prosecute. That is, internally, making very clear so that other researchers can examine why it was that the agency decided to act or not to act. And John and other colleagues have mentioned this already. Spelling out those key assumptions is crucial to going back later and asking, how did it turn out? And if it didn't turn out, not simply to know that it didn't turn out, and here I echo something Dennis has mentioned many times, the point of doing the assessment in so many ways is to do it better the next time from the agency's point of view. So what do we learn about improving the methodology the next time around? An example of how this can be very informative, the FTC in the mid-2000s approved a joint venture of Lockheed Martin and Boeing to create a merger to monopoly, basically, in heavy launch vehicles for national security launches. There were two crucial assumptions that supported the decision: an efficiencies argument about how consolidating greater experience in a single team would improve reliability, and a second about entry, that the U.S. government would over time promote the entrance of a new firm into the sector. We know over time that that happened. ULA has not had a launch failure in its entire existence. That was one of the hoped for efficiency gains, greater reliability. And there was entry. Elon Musk, SpaceX, Blue Origin, several others, with the United States government assisting in that process. By providing and identifying the assumptions, one had an opportunity not just to ask, were those assumptions fulfilled, but if not, why weren't they? But perhaps as important, if they were, for reasons we anticipated or for reasons that we didn't have in mind at all, and to inject that knowledge back into the review of the next transactions. Another way to improve the analytical baseline, especially for outsiders, are informative closing statements. The U.S. at a minimum should adopt the practice that's common in other countries, but where the U.S. uses compulsory process to conduct a major investigation, it ought to explain in informative detail why it decided to close the file, to promote the debate and evaluation of whether or not the decision not to prosecute made sense, and to track that over time. Second, we've had several discussions, I think, of the crucial fact that there is big data. We talk about big data that firms collect. There's huge antitrust data that the antitrust agencies themselves have. They've accumulated consolidated experience across a wide array of cases. It's useful to think in terms of building industry biographies, which enable the agency within an industry or sector to have a better intuition about how to act and decide in the next case. Example of how that could have been brought to bear on a merger at an earlier time. Baby food, Heinz. In the late 1970s, when I was working on impact evaluations involving vertical restraints and helping Tim Bresnahan, young promising academic who's gone on to great things, do the Xerox investigation, we were performing an assessment of whether to bring a no-fault monopolization case. Which company was at the top of our list was going to be the test candidate? It never proceeded. That was Gerber. Why? For the better part of a half century, they had a durable, significant market share that was impervious to entry on many fronts. The Heinz and Beechnut merger would have confronted Gerber with a strong second firm. Thus, if you assume that Gerber was durable and that sweet little cherub had such brand loyalty that parents would always come back to it again and again, maybe it was not a great risk to think of creating a second to go after it. That knowledge gained from the no-fault monopolization inquiry never made its way into the assessment. Maybe you'd still decide to block it because you're not going to block what was seen to be a 3-2. But if you were thinking of taking a bit of a chance in your portfolio, knowing that Gerber had been so durable, you build into your analysis what you'd learned in these earlier exercises, and you bring that to bear in deciding whether or not you're going to challenge the transaction. In thinking about innovation markets, I think of the roughly 40 to 50 transactions that FTC and DOJ have done in the defense and aerospace sector. I think there's an enormous body of information there that can teach us a lot about innovation. What innovation skills and disciplines predict success? What past activity indicates whether the innovator is likely to do it again? Where do new entrants have a big impact? There's a massive amount that one can learn in transactions that again and again treat price as a completely secondary consideration. It is the impact on quality and innovation that has meant most to the purchaser. Third, dealing with resources again. On Nancy's important theme about what you do if you don't get the additional resources, or my plea, good salaries for the people who come to work to the agencies. First, several colleagues have mentioned, I think you can do quick looks You can do quick looks with a fairly austere record if those priors are well stated, and you can go back and say, did actual experience meet the priors, with the idea of answering Dennis's crucial question, what does that tell us about how to do it better the next time? The CMA, with respect to merger process and to all of its competition cases, routinely does quick look-backs about the method that the institution used to do studies. They do these almost across the board with the spirit that the results of this will not be a source of retribution for people who failed or for things that haven't gone well. They've built a norm that says the only reason we're doing the look back is to do it better the next time. Those have been extremely informative. Second, as Nancy was saying, how to enlist co-producers in this effort to share the burden. A good way to think about how to structure the academic partnership is to look at the FTC's first modern impact evaluation effort that was launched by Jack Kirkwood, 1978-79, guided by Bob Land, to evaluate the effects of the FTC's vertical restraints enforcement program. That was a wonderful collaboration between academia and the agency, with senior researchers like Dick Caves, who have designed the protocol for the study, young promising academics who ascend to significant positions in academia later on, first for the vertical restraints program, then for the Xerox case, in which I had a hand with Tim Bresnahan. Tim did the work, I did the contracting documents. So obviously I had a heavy burden there. But Tim publishes the most informative study we have of the effect of the Xerox case. That protocol, that experience is extremely informative about how to do it again. How to bring academics at relatively low cost, how to offer them data, how to give them publication possibilities, and very good publications they were in luminous places over time. You can build upon that model, I think, quite successfully to have a collaboration that works. And yes, you can do the collaboration internationally with other governments that have a shared interest, common research projects about common sectors, looking at mergers and transactions, which increasingly several different agencies have looked at. Pick a couple of partners who have an interest in doing the same thing. Last, how to sustain this from an institutional point of view. First, I think you build focal points to do that. One is to continue the habit of drawing attention to the subject in gatherings like this. This can be a routine feature of the microeconomics conference that BE organizes quite successfully. It could be the standalone annual event called the Evaluation Conference. That could be an FTC DOJ production. That could be a joint venture with a major academic research institution with a shared interest, where the focal points are: do your papers on advances in methodology, do your papers that involve case studies, do your papers that provide the more detailed quantitative empirical studies. You can also use, as John was just mentioning before, settlements and litigation as an avenue to prompt this. It's striking in the area of monopolization litigation. The AT&T decree that Judge Green signed had a specific provision that said, we are coming back in 10 years to evaluate the effects of this. Judge Wyszynski in United Shoe Machinery did the same thing in his 1954 decree. That is, you could have judges, more as a matter of routine, saying, we are going to come back and take a look at this. That could be a condition that's built into consent decrees as a routine element, at least for some transactions, to come back and look again. And last, the suggestion that I think has come up in many of the discussions here, I think it's a mistake to put cartels, mergers, and conduct in watertight compartments. There's so much, I think, to be learned across these areas, the way in which what we've learned about cartels feeds into coordinated effects analysis and mergers. What we learn in individual sectors about how they have evolved over time and how competition law, its absence or its presence, has affected the way they've grown. To teach staff to draw connections among them so that when they're doing work on individual cases, they're not just handling the horizontal restraints case or the merger case or the dominance case, but they're thinking about how building a body of knowledge that will be useful to apply across the whole piece of what the agency does. Thanks.
All right, thank you, Bill. Mark? Marty?
Well, thanks. I want to first thank Bruce and Dan and everybody who I know worked so hard on putting this together. This has really been a terrific day. And I want to thank the commission for having the foresight to hold this hearing, but all the hearings, to really try and look at a set of very, very important issues. So I have 4 broad points about retrospectives, and they're as follows. 1, do them. 2, do them regularly. 3, be selective. And 4, do more than just horizontal mergers. I'll elaborate a little bit, but the rest is just commentary. So retrospectives are very important, and I think there's universal agreement on that. But let's be clear about one of the reasons they're important is that it's really critical for the agencies not simply to be reactive. There is a tidal wave of stuff, as we've heard already, coming over the transom. And the agencies could be simply swept under that tidal wave and simply react to this, that, and the other thing, and not make investments in the future. And retrospectives are part of that absolutely essential investment program. Now, having said that, not all potential retrospectives are good candidates. We already heard a lot about that. So it's important to be selective. I think it's very, very important to have dedicated resources to do this on an ongoing basis. It can't simply be on an ad hoc periodic basis. It has to be part of what the agency does. Now, of course, it would be wonderful if Congress would appropriate more funding. I am 1,000% in agreement with Nancy and with Bill. It's not just a question of money. It's a question of the salary levels that people are paid. The people here are every bit as good. No, I'm wrong. I'm sorry. They're better than folks at the Fed or at the CFPB, yet the salary levels are not commensurate, and that is a serious and ongoing problem. Let's think a little bit about criteria for retrospectives, and this will be at a fairly high level. I'm not going to be as specific as some other folks, and these are really kind of obvious, but I haven't heard it said yet, and maybe they're so obvious nobody needs to say it, but I'll say it anyhow. Focus on enforcement areas that are key. That's one. Focus among those on areas where you really need evidence, or evidence could be the most productive. There may be some key enforcement areas where for right now the agency is just humming along and the models seem to be working really well and things are going well in court. Then maybe you don't need additional study, at least for the time being, in those areas. And last, of course, you have to look at where retrospectives are going to be most likely to be valid, because like I said, we heard throughout the day, not every retrospective is one that can be done in a scientifically valid way. Some thoughts on areas I won't call new, but newish areas for retrospectives, or just not simply horizontal mergers. And we've heard about many of these already, but agency actions, enforcement actions, decisions, rather, remedies, those really do need to be evaluated on a regular basis. We heard a bit about labor markets, but I think monopsony more broadly, that includes labor markets. Of course, they're absolutely critical, but there are other markets where there potentially is buyer market power, where mergers, for example, might create harm to competition in the buying market that should be examined. We've heard about non-reportable mergers. There has been some examination of those by Tom Woolman at Chicago, and that's certainly a great start, but we need to know more. We've heard a lot about potential competitors. Again, that is not an easy area, but is potentially very important. So really some very hard thought needs to be devoted to that. We've heard about vertical. Again, it's always been important, but particularly if we look at certain industries or certain markets in the economy, there has been a lot of consolidation. And I want to be clear, consolidation, market structure are not where we stop. But if we see markets that are dominated by a firm, then we start worrying a lot more about what comes next, because once you have market power, you want to keep it. You probably want to enhance it. And vertical issues start to become much more germane at that point in time. The next logical thing, of course, is anti-competitive conduct more broadly, and I'll throw a very broad umbrella over that. I'll include coordinated effects under that exclusion, a wide variety, most favored customer clauses, a wide variety of conduct. And the last area that is not necessarily an antitrust area is consumer protection. So there may be some overlap, of course, between consumer protection and antitrust. But I think this is a particularly important area. I think the value added to studies done, retrospectives done in consumer protection, particularly high. Well, why is that? It's relatively unexamined. It's an area that is sorely in need of more study. The agencies are in a perfect position to do it or to commission studies. And actions in this area have been far from consistent. Some might say they're inconsistent. Some might even say they've been incoherent. And so consumer protection is an area where the benefits to retrospectives could be extremely high. Now, having said all that, some of these things may be complicated, may be very, very complicated. If you start to think about some of these issues, exactly how to learn about these sorts of things from retrospectives is unclear. One example is counterfactuals may not be at all clear, but that's why we have to think hard about these things. And it may be that the agency concludes that some of these are not good candidates for study, but it's important. Now, last, I'd say, while it's very, very important to take this on, one can't do everything, and I'll finish with a maxim that comes from a collection of sayings attributed to sages from ancient times called Wisdom of the Elders. It's attributed to Rabbi Tarfon, and it says, "It's not your responsibility to finish the work, but neither are you free to desist from it." Thank you.
Thanks, Marty. Dennis.
Okay, thank you. So literally the last one of all the speakers for the whole day, and there's not all that much for me to add to their excellent comments, but maybe I can at least put them in a perspective that I hope you'll agree with. And you'll also agree that when you want to teach, the best way is to say, here's what I'm going to do at the beginning of the day. So we heard that from Joe. And then you do what you do during the day, during your lecture, and then you hopefully say, this is what you should have taken away from my lecture today. So by being the last person, hopefully I can, without offending anyone or misrepresenting their views, at least give you my take on what you should take away from today. So first, let me say it's a pleasure to be here, and I applaud the FTC for holding a hearing on this topic. The topic of merger retrospectives, in my view, is a key one, an important one, because it holds the promise that it could improve our ability to identify good mergers and bad mergers, to distinguish between the two at the evaluation stage. And as Bill has indicated earlier and some other speakers, I've been interested in this topic for a long time. I wrote a paper on the importance of merger retrospectives, as well as the difficulties of doing them. By that I mean there are certain self-selection problems that arise. It's not a random sample. A number of people have referred to that, and I explained in this article how you can correct for that. And if you don't correct for that, you can get the wrong answer. But assuming you do it right, retrospectives can be extremely valuable under certain conditions. And the first, probably most important point to take away is that these retrospective studies can be important really only if they help the decision maker alter his decisions from what he would have done before you told him what your findings were. So if I'm an enforcer and I look at 100 mergers and they all basically look the same to me, and I let them all go through, and then you come to me and say, Dennis, I just studied this merger, these 100 mergers. On mergers 1, 2, and 3, you really blew it. But the rest, you were pretty good. And I'll say, well, is that all you can tell me? What did I do wrong? And if you say, I don't know what you did wrong, I'm only here to tabulate the data, I say, well, thank you very much. That's interesting, but you're not of much help. On the other hand, if you say, gee, those 3 mergers were always in the same industry, and those were the only mergers you saw. Or if you tell me, here are the characteristics of those 3 mergers that you missed, That is helpful. So I want to explain how you would implement such policy. So I'm going to disagree with something Limor said, and more agree with what Debbie said in response, and that is, here's how I do it. At the time a merger is allowed to go forward or challenged, I want the economists at either the FTC or DOJ to tell me why their recommendation is what it is. I want to know, did they do retrospective mergers in that industry and what it showed? Did they do a reduced form analysis like the one Orly was talking about that he did in the Staples case? Did they do a merger simulation model, either horizontal if it's a horizontal case or vertical if it's a more complicated one of these vertical merger cases? And in that simulation model, what was their demand structure? What did they assume about costs? What did they assume about competition? What did they assume about entry? What did they assume about product innovation? What did they assume about efficiencies? And I wanted to see what they're saying. And then what I'm going to do is say, let's do a merger retrospective. Like I say, assuming you can do it correctly, I want to know what happened to price. And by the way, everybody always talks about price, and as John Cuoco said earlier, there's a focus on price. It's an undue focus. You want to look at what happens to other things too. It's not just price going up. If price goes up and you think it's bad, output should go down. What happened to output? What happened to efficiencies? What happened to repositioning? What happened to the quality of the product? What happened to entry? What happened to innovation? All of those things I want to see what actually happened. And then what I want to do is figure out, if I was wrong, why I was wrong. And let me tell you how I would do it. And there was an excellent article on this by Craig Peters. It hasn't been mentioned yet. It was in the Journal of Law and Economics. And he does something like what I'm going to describe, very similar. First, I look at what happened. I look at, say I used a merger simulation model. Did I do something wrong? Did I get it wrong? Because my demand system is wrong. I can check ex post whether my demand system is the right one. Had I used a different demand system, would I have done better? Why? Maybe that's the demand system that has better second-order properties. What about other variables that are changing? Maybe that's why my prediction is wrong. And suppose those other variables have nothing to do with market structure. So suppose the demand curve depends on income, or I think someone used the example, the price of corn. I can calculate if I have a structural model, how that would have been taken into account, and then I can therefore isolate that out of the model and say, well, what's my prediction correcting for the fact that the world has changed? But I can go further. And this, I think, is key, and a few other people have already mentioned it, especially in the panel before the break. You want to focus on the supply side. These merger simulation models all use a static Bertrand concept, or most of them do. You can test that. When merger simulation models first came out in the 90s, people occasionally, not always, would test, is it Bertrand? No one does that anymore. It's gone out of style, okay? Except for the papers that we heard earlier today, who are bringing back into style, testing whether the Bertrand assumption is good. They brought it in by explaining that, which is true, we've ignored cooperation, oligopolistic behavior. We don't model those in these merger simulation models. So we heard a little bit today about how some papers are dealing with that problem. But what no paper has dealt with, and this is an area of future research, how does the oligopolistic game played differ after merger compared to pre-merger? That's a really hard question. I hope people will write dissertations on that and work on that. That's a hard problem. Am I wrong ex post when I see what marginal cost is compared to what I predicted it was going to be? That's actually tied to what I just said before about Bertrand competition. The way these merger simulation models work, sometimes it sounds counterintuitive, but in a lot of cases, people don't look at costs. They look only at demand, they invert the demand system, and they come up with marginal cost. They're inverting the demand system, assuming Bertrand competition. If you don't have Bertrand competition, you're going to get wacky marginal costs. That's therefore a clue. That's a bad assumption. Where the efficiency achieved in these models? And let me just mention something that's not been discussed at all or brought up. These merger simulation models often use linear prices. There's one thing you learn when you get into the details of studying an individual industry is that the prices are much more complex than linear prices. And if that's true, your merger simulation results are going to be, or could be, way off. Just mention briefly these vertical models. Is that a zero? I have my reading glasses on. 1 minute, okay. In these vertical models, which are called Nash and Nash, you're basically putting a cooperative model of Nash bargaining onto a merger simulation model. You can make the Nash and Nash, the Nash bargaining model sometimes non-cooperative, but basically you're making lots of assumptions. And in these Nash bargaining models, as Aviv referred to, the bargaining parameter matters, as well as, no one's mentioned it, but it's something called the no agreement point. What's the no agreement point? That's what happens when you can't reach agreement. Those are really hard to model. That's all I'll say. And one of the things I would check on these vertical models are whether you're getting those right ex post. So there's a lot of opportunity ex post to figure out why our methods, which parts of our methods need improvement. And that's what we should be focusing on. And let me just end by saying I agree, and I think Bill just mentioned this, that you can do these same types of retrospective studies, not just on mergers, which are obviously important, but you could do it on a variety of conduct measures. The FTC has a famous volume on resale price maintenance it did in the 80s. You could look, now that we've gotten rid of some resale price maintenance, or states have put them on again, what happens, okay? You could look at what's been happening, and I think Oli's done a lot of work on this, where we see a rise of non-compete clauses in certain types of contracts, labor contracts, what happens. All of those could be done in the context of a structural model. So, and you could see using these structural models and using cases where certain practices are banned. What happens? Were our models correct in predicting what would happen? So I think these retrospective merger studies are very important. I think they hold the promise, if we can use them to figure out what we did wrong, I think they hold the promise of improving our antitrust policy. So, thank you.
Okay, and I guess the challenge of everything having already been said and asked applies to the moderator of the last panel. But I will say a couple things before I ask my first question. Orly, I don't know if Orly said, Bruce, I can't believe you're working for the federal government. And Commissioner Slaughter mentioned that I went on an ABA spring meeting panel. It was the director's panel, and I said something about we need more resources. And I went to George Mason the other day, and people yelled at me. Somebody called me a Niskanen bureaucrat. But let me think about it. I do think that is a serious problem, and if you look at what is going on, is that people want us to do something, and they ask the bureaus, other than the Bureau of Economics, for their resource ask, and some of them were like large resource asks, and what you would do with them. And thankfully, I think both the bureau directors said, oh, by the way, if you increase the workload 10%, you have to increase BE by 10%, because the derived demand for the services of the economists are going to go up commensurately. And what I said and I didn't sleep that night, is that, you know, if you want us to do research, then you had to do BE, you know, disproportionately. And that's why I got yelled at when I went back to my law school. But it's really true, and I think something that Mike, who's my deputy for research, gave me, he gave me what has happened to build time by our economists and research over the past 9 years. And I mean, it's like the equivalent of 5 FTEs full time. Commissioner Slaughter said, yeah, you look at the HSR filings you have to deal with and our caseload, and you know why that happens. But you know, certainly resources are a big problem. With respect to retrospectives, I think the bigger constraint, I think if there was a great retrospective project to do, I think one of our economists would find the time. Whether, you know, we had a furlough, so we had, you know, people did a lot of research then, but it wasn't billed. But they'd find time to do the projects because they were interesting. I think the biggest constraint is data. And so a lot of the questions is yeah, I mean, you guys should, I mean, I had a bunch of questions, and the answer is, yeah, you should do as much as you can. You should do all of it if you can. You should get more money. And that's, like, not very interesting. So the big question is, and I think Aviv said that he stole my thunder when he used the economist under the lamppost metaphor, but I think that's a bigger constraint than I'm not downplaying the resource thing, but the data, and Mike mentioned that. I mean, you look at Quokka's book, John's book, and you know, he has a comprehensive sample of what people have done, and there, you know, you look at what we've done in the 30-odd studies that we've done, and it's hospitals, oil. It's, you know, we look where the data is, and so I guess the issue is not so much thinking about the money, because that's way beyond my pay grade, but I mean, there's data. So we do hospitals because we have either the discharge data or the insurance data. So we have the data. I know that some of the work Dan has done, it's retail, and well, it's Nielsen, right? There's data. The oil price, we have the oil price data. And so I guess the question said, is there some industry that we should look at? And the question is, yeah, the ones that are problematic or ones where you don't know a lot, but is there data that you know, assuming away sort of the 6B question or the insisting on it at the end of an investigation, is there data that is out there that we would find useful that we could buy?
I'll just take a stab at that, Bruce, which is I suspect that's not where your highest return is going to be, right? If there are data out there that people can access in academia that provide the opportunity to do interesting research, somebody's likely to have already grabbed it. I think that's why John's set of studies, you know, you look at banking, you look at oil, you look at airlines, you look at hospitals, you look at pharma, you're picking industries where there are available data sets, often proprietary, not necessarily public, but either public or proprietary that you can access, that you can buy access to or get access to let you do those studies. I think we should be very concerned that we know very little about retrospectives in industries that are outside of those.
Yeah, let me just jump in and second that concern completely. You know, we know an enormous amount about the airline industry. All of my PhD students write at least one essay on the airline industry. And I've sometimes said that if the airline industry could collectively accomplish one thing, they would end the reporting requirement that they are subject to. Or put differently, if we had the same amount of data on, pick an industry, like Nancy says, that we might think otherwise is problematic, if we had the similar data on that industry, we would know a great deal more. So data really, I think, is the single biggest driver of the focus of these. Let me make a somewhat unrelated point, which is, I think, equally obvious, and that is that retrospectives are an investment good on the part of the agency. The idea is not just to add to the burden of the agencies, though that surely will do that. in the moment. But the idea is to make, say, merger policy more effective and more efficient at the point where there's a body of evidence to rely on and to deploy in approaching investigations and resolutions of mergers down the road. So, if some number of retrospectives were done every year, in 5 years or whatever, there would be considerable more insight into how to pursue investigations or what strategies are appropriate or how to resolve mergers. And that might be effective within the agencies, perhaps not in court, but certainly within the agencies in determining where to deploy their resources at that time.
Yeah, I think, John, you point to a crucial choice that an agency has. Do you consume or you invest? The consumption is the next case. It's the next investigation. The investment is the outlay for activities that make you better in doing all these things. And that's a very hard choice in this town. I think what is healthy about the culture that's developed at the commission is that it's accepted the notion that investment is significant. So I think it would be receptive to undertaking that kind of approach. And I can recall working with the team that worked on the early evaluations in the late 70s. That was a hard sell for several reasons. One is it was going to take money away from cases. The second was, what are you going to learn from doing the assessment? Maybe you'll learn that you did just the right thing. Maybe you'll learn that you had no effect at all. Or maybe you'll learn that you made it worse. And two of those three things are bad. Let's just say it's the first and leave it at that. It was not obvious, especially to case handlers, that it was a good idea to run projects to go back and ask how we'd done, fearing that this would be an occasion, again, to go out and shoot the wounded and to use it as a source of retribution. I think what's been very healthy that would lay a foundation for doing more investment is that resistance, I think, has, if not disappeared, it's been weakened. And quite happily, I think there's a sense that the investment is indispensable to effective policymaking. And I think that sets an environment in which you could do more.
So, Bill, can I ask you a question as the lawyer designated representative on the panel? One of the things that I think concerns some within the agencies, and maybe this is more significant in DOJ given its kind of structure and function, but is that if you do a retrospective, you should expect it can and will be used against you in a court of law. And we had an experience with that in the Electrolux GE merger investigation where the parties wanted to use a retrospective of Whirlpool Maytag to argue that there wouldn't be any effect of this merger. Now, there are a lot of reasons why that was crazy in that particular context, and the way it was pitched didn't make a lot of sense. But it does create a risk because if the retrospective is done by the agency even, it assumes maybe a greater credibility before a judge. And I frankly do worry a bit that if retrospectives are used to defeat later enforcement actions, maybe they're not so helpful.
Oh, I think it is a risk, and to punctuate it in the vertical restraints assessments, the fiercest opposition we received was from the case handlers who were working on a matter called Beltone, which was one of the subjects of the inquiry. And they said, why would we ever run an assessment in an area where that study, if it comes out badly for us, it did, will be used against us, it was, and we'll lose the case, we did. So every set of possibilities that they feared came to pass. And I think it's a risk that one assumes. I suppose the faith I would have is that doing a large enough number, having a careful examination and assessment of why things went wrong, ultimately gives you more credibility and legitimacy in front of the courts when you offer the interpretation of your work. I see it as a way of branding yourself as an agency that is saying, we go where the data goes, we go where the facts go, and if for some reason we're not doing quite the right things, we do them differently in the future. So that when we stand before you and ask for that margin of discretion in the case where it is a matter of judgment, you'll trust us because we have shown you that ultimately we want the good policy result. And I say it as someone who faced exactly the scenario that you described. In Electrolux, it did not get in the way of a good result for the Department of Justice. In Belltown, it's probably a case we should have lost anyway. But I think when I look at the entire set of possibilities, I would rather be in the position of the agency of doing a large enough body of work and saying, if it turns out, and I'm assuming that it's a well-done study that genuinely undermines the position that one is trying to support. If it is a well-done study and it points to a different direction you should be taking, that's the direction to take. I can see the problem that a court might not interpret it properly. That's always a problem with the work. But I see ultimately for the agency that it builds a sense of confidence, accountability, credibility to take that chance in the hope that you get enough other things that point you in a good policy path. So like hospitals will be the main case. And that's the one that you have. And but I would not, I can't wave my hands and say that it's always a happy end in that respect because these can come back and hit you. And Belltown's a good example.
So, Bill, let me, while we're piling on, Bill Kovacic, let me ask a question about closing statements.
Pat Benatar said, hit me with your best shot.
I'll save that for later. But how about asking about closing statements? So closing statements, of course, are they're fulsome
For
statements.
the younger people here, that's she was a singer a while ago. Sorry.
No, it's okay. So whenever I mention closing statements, people at the FTC shudder. They talk about the one that was issued after the Office Depot Office Max merger, which came back to haunt the agency in its effort to stop the Staples merger with the combined Office Depot Office Max, as illustrative of the price you pay for describing, either in short or maybe even more dangerously at length, the basis for clearing a previous merger that had the same players and some of the same properties. Mm-hmm. Obviously, in the EU, with the administrative rather than a more judicial litigative forum, providing full statements is standard policy. But again, here, it seems that there raises obstacles because then the agency will have to explain why the merger they want to challenge that's in front of them differs from every other merger to which the parties might compare some aspect of the one in front of the court.
Could I just put in here? I think I'm troubled by the whole question. The goal of the FTC and DOJ isn't to win cases. It's to get them right. And if there's studies you do that conflict with a DOJ or FTC's position, I'd like to see those. If I'm in the DOJ or if I'm against the DOJ or if I'm in the FTC or against the FTC. We want to get the policy right. And I dislike hearing, or it makes me uncomfortable hearing, that we should tailor what the Commission or the DOJ does in order to win cases. I want them to lay out their logic. What are they thinking? And if it's right and in the next case it turns out not to be applicable, they should explain it. Now, if you think judges are too stupid to figure this out, I don't quite know what to say. Well, maybe we should be educating judges, but at least let's educate ourselves so that we know what the right answer is. And
so, Dennis, I think that's a complete mischaracterization of what I said. And of the example that I gave. The issue is not whether the division got it right in Whirlpool Maytag and therefore should not have challenged. The issue is that they were two completely different mergers. Yes, they both happen to involve appliances. I don't interpret, actually, the facts to suggest that the challenge in GE Electrolux was wrong. I think it was completely correct. But the point is that parties have an incentive to take official statements of agencies, be they closing statements or retrospectives. This wasn't a retrospective done by DOJ. And frankly, confuse judges who are not economic experts. And you may be right, Bill may be right, that in fact, in the discussions when, truth will prevail, but it adds an extra layer of complexity and problem that, as John pointed out, the EC doesn't have because it doesn't have this.
Oh, they get sued on the basis of these statements. They do. They
Not
don't
so
get a
much in
free pass.
mergers.
Oh, yes. Oh, yes. Yes, indeed. They are subject to lawsuits on the ground that the actions taken by the institution were too weak, that they took a cheap deal or closed the file.
Oh, no, I'm just saying in a later merger. I think what John was saying is.
He was talking about closing statements.
Right.
How they're used in a subsequent.
Right, it's the subsequent use of them that makes me concerned, because it's easy it can be difficult for people to understand, is there really an obvious connection between the two?
Then isn't that the burden of the analyst to explain, or whoever has done the study or is relying on this study, that who wants to defend against it being misused, that this is how it's being misused? I'd rather see the study come out and have people debate how to interpret it than not do the study, because the study could be quite informative to improving policy.
Everyone's always free to do the studies. I'm just pointing out a risk of these that I think is real and significant. And in my experience, given the way the burdens are in court proceedings, defendants have every incentive to throw lots of little bits of Mylar into the air and hope that the judge's attention is distracted towards some of them.
Don't you think the solution is to try and correct that in some way, not to do the study?
Well, let me suggest something that may be a little dangerous, stepping in here, but I think probably I agree with these points, but if it's a study that seems ex ante, will be a very high quality study. Personally, I'm far less concerned. My view would be, let's do it, let's take the risks, and we'll just deal with it. Now, if you're looking at something prospectively and you're a little more dubious, then I think I start worrying, both because it's internally hard to interpret anyhow, but then somebody will grab some piece of that and potentially try and use it against you. So that may be another part of the cost-benefit calculus. But I think if we think it's a good study that will help inform the agency, that's an investment in future actions, then I think we just have to go ahead and do it.
I'm not disagreeing. I'm just saying, I think it's not an unalloyed plus. There are costs we should be aware of.
Oh, as mentioned before, they exist. They exist. I think the happy interpretation is that in GE Electrolux, in Office Depot, Staples, Part 2, these matters did ultimately not have that effect on the court. They required effort to explain. But on closing statements, I think they've been such a good discipline. And before Carnival Cruise Lines, in the early 2000s, the FTC's number of closing statements for the previous 25 years had been exactly one. That was Boeing McDonnell Douglas. And again, I would say when you do an elaborate inquiry and you close a file, to explain why, I guess I have faith in that with the continuing improvement in the analytical technique, that despite the chaff that's going to be thrown at you, just as Nancy mentioned, I'd accept the cost because of the legitimacy. And I'll mention exactly the legitimacy I have in mind and the credibility. It's going 3 blocks away here to the Court of Appeals in particular. Those judges, agencies have brands and reputations when they stand in front of those judges, and the judges have a good sense of what you do over time. I always wanted our people to stand before them with a halo before they said a word. And part of the halo comes from saying, we're aware of this, but we put our cards face up. In the math exam, we show our work, and we realize that we get buffeted as a result. But when we ask you at that decisive moment, especially as an administrative agency, trust our judgment and defer, that's the moment at which I want them to think, I'll do it because I trust you. But I agree, Nancy, there's a risk.
So let me wade into the issue about what judges know and how we should proceed in court. I've observed a number of times that in full trials where both sides get to present all of the evidence for and against, say, a merger, not infrequently, it's still impossible for observers to anticipate how the judge will rule. Take any recent famous case you wish, where there's wild speculation about how it might come out. It clearly depends on the judge. It doesn't, the weighing of the facts and the final assessment will be different depending on who the judge is. That's a crazy, crazy process. How can we, in fact, decide that that's a sensible way of doing it, only eventually to be screened perhaps at the appeals level? There's something wrong with the process where the full elaboration of the evidence doesn't give most people a pretty good prediction of how it should come out. So my suggestion is that we have 3 judge panels for antitrust trials, that will minimize the idiosyncratic nature of a single judge that has some predilection or prior or whatever it may be that allows this kind of incredibly high variance outcome to the single sample out of the population of judges.
And my suggestion is we do a retrospective study of John's policy change. We can identify all kinds of structural parameters.
Right, we could randomly experiment with panels of different sizes.
Bruce, did you have questions for us today?
No, you know,
Did
the nice thing about being a moderator on a panel like this is I get to shirk. It's great. I just want to say that John mentioned the closing statement in Office Depot, Office Max, and it said, I mean, the type of entry-exit analysis that was done, you know, when Orly did Office Depot 20th Century was not there in Office Depot, Office Max, and you know, the staff did the same thing for Office Depot Staples 21st Century or 2, right? And what they proceeded on was a different, wholly different theory about sale to businesses. And I guess maybe it's not a clean test because the defense decided to rest instead of putting on their case, which is an error. But yeah, I think transparency is good. It does constrain the agency, and there is a cost, and it's going to raise, I guess, the number of type 2 errors, right? So anyways, so I could go to a second question, or maybe there'll be blood, right? So I guess the first question was, are there any $20 bills on the sidewalk? And the answer is no. Although I have to say, I was walking my dog this morning, and I found a $5 bill. And I looked at it, and I just left it there. All right. So the other thing that I wanted to ask about, and it was mentioned by some people, is 6B. Once again, 6B is our ability to subpoena data for large studies. I guess the famous version of that is the line of business data, where we forced firms to come up with their own idiosyncratic accounting systems. But I guess people have mentioned it. So what would a 6B study look like? Would it be to create sort of an industry tracking? You can imagine the industry going screaming to Congress about that. Would it be sort of us looking at, our ability, even if you sort of get in the investigational data, the parties' data, trying to get third-party data, because you'd probably need some of that to do a retrospective. I mean, what would that process look like? And then I guess the other question is, and this is probably most for Bill, can we then share that data outside the agency? Because you were both the chairman of the commission and the general counsel, so.
On the second, you can. Now, there will be, as you know, the purpose of the line of business data was to publish the data, and several years of the data set were published. Now, there were amalgamations that prevented, I think, in specific instances, if I recall correctly, the identification of individual firms. But that's a faint memory. But the intended consequence of it was to put this data set in the public domain. And I'm trying to recall how many years of information. Dave Ravenscraft was I believe, the internal architect of the process, and I think it was 3 years. So the short answer is yes, in various forms you can. And on the subject of what you'd collect, I mean, one interrogatory I could imagine where you're simply trying to test efficiency predictions made by the firm, realizing that they're predictions, they're making predictions as well. But during the course of the analysis, you made the following representations about efficiencies and other things that you thought would mitigate possible competitive harm and would ensure a good competitive result. We'd like to track how well things have gone on that. And here are questions we have about that. That would be a specific kind of question that I don't think might not be too intrusive to answer, just on the question of how it turned out. And I'm thinking again, I'm anchored by Dennis's observation that what I want to do in developing it is to enable me to identify in a clear-headed way what to ask about the next time, and to decide, make a better judgment about whether or not the argument should be credited or not in the next time around. Not just to see whether it happened. I want to know, as Dennis was saying, why did it happen? Why did I miss it?
Anybody else want to take a stab at a 6B study? A lot of people looking down, right?
Well, briefly, one thing, I think just reiterating what Bill said, there's been a lot of talk today about understanding not just what, but why. And I think one of the potentials with 6B is getting behind that. And some of that may be qualitative as well as quantitative. But in terms of informing the agency about how to think about how these things work going forward and why things go a certain way, then I think there is some potential from 6B that you might not, where you might not be able to get the same kind of information otherwise. And 6B has to be used in a very judicious manner. It's not meant to be deployed by the agency in a capricious manner at all.
I don't know, I'm not an attorney, and I don't really have much expertise in interpreting 6B, but there's one point I want to make about data. If you collect data from a firm after they've merged, the question is they're aware you've collected that data or that you're going to be getting that data, and that also will affect their actions or could affect their actions. So you have to kind of factor in that aspect to the analysis. It's not just you're observing data that has no effect on it's the act of collecting the data could alter the actions, and I think you want to think that through in your analysis.
There was a event held here, perhaps even in this room, on the painful day of September 11th, 2001, where there was a I/O roundtable.
I ran that.
Yes, we were here, both of us. I was watching, you were at the table, but I recall at the end of the session in the afternoon, the question came back to, and there's a transcript on the agency's website that records all of this. The question was, what do you do when you have an intriguing efficiency story, but it is speculative, but you're deciding that the potential benefits of it, if it comes to pass, are strong enough that you would like to take a calculated risk that it would work out, but you're uncertain about whether or not it is likely to come about or not. And a couple of the panelists said, you could offer an approval with this condition. We will come back at some point to see whether these things took place. And I recall that a concern was, yes, now they know they're on stage, how will it shape the way things happen? But others said, might that be the only way to really test that, because the alternative will be we'll issue a prohibition decision. We won't go ahead. So is it either going to be subject to manipulation, or is it a way that the firm in a way makes a credible commitment that says we really do believe in this and you can come back and check later?
Yes, there's one other thing I want to say. There are some industries in which you see the same firm having a sequence of acquisitions. So you can actually test from the past what they've said, whether that actually turns out to be true. The only other thing I'd say about that conference that I helped organize is I showed up at the entry level and I hadn't listened to the news. And the woman says, who are you? I say, I'm here for this conference. She says, you understand that, the plane just went into the Pentagon and there were soldiers in the street. I really didn't know what was going on. And I said, listen, Tim Uris wants this conference. I bet if he's in the building, he's going to say, let's hold the conference. And that's what he said. And that just shows the commitment of the FTC to getting the unvarnished truth from economists. So, all right, to their credit.
So could I just follow up with that with another question, which is, doesn't it depend a bit on why you're collecting the data? So in the example that you gave, that you may alter the behavior of the firm, but that's intentional and beneficial. I think the mistake would just be then to look at that outcome and say, well, therefore, we should accept these kinds of efficiency arguments when we don't have the intent to collect the subsequent data. I think that's a little bit of a problem in some of these mergers that get settled, particularly with conduct remedies. And you say, well, look, the firms didn't raise the price or didn't do this bad behavior, but they're still operating under a consent decree. It's a little hard to know, well, as soon as that consent decree lapses, what will the behavior be? If your intent is for the duration of the decree or for the duration of the time you're investigating the follow-up data, or do you see these things put into place that affect the efficiencies? Does that happen in this case? Great, but we shouldn't think of that as a lesson necessarily for how to make that decision in the future unless it's also accompanied by those.
Yeah, I would want to think very clearly as an institution about why the behavior in question has taken place, and under what circumstances would it take place again in another setting, what kind of observation and monitoring is required, because these are strategic actors.
Right.
Yeah, I think I think Chris is working on something that is related, whether it's the COPA laws, and it's sort of a type of behavioral remedy where a state says, well, I know you don't want this hospital merger to go through, but let's let the in-state hospitals get a certificate of public advantage, and we let it through, and often they're let through with behavioral remedies. And I think, it matters. I mean, some of the points that were made earlier today is, during the time when the constraint's active, you don't see any effect. And I think you see effects that are long-term when they're not constrained. And, a lot of these things is, you have to figure out what the right inference is from the study. I know Commissioner Slaughter talked about, we're going to threaten to collect data and look back, and the other way to do it is we're going to give you immunity so we learn something. And I think she throws me out of the office at that point. But it is another one of these trade-offs that we've been discussing about learning stuff and being able to make specific inferences about a specific question versus, trying to do law enforcement. So we have less than 2 minutes left. Any other sort of really, anybody want to close or toss out some more heated questions?
I would just second the suggestion that several people have made that, or implied that having a visitor program where, say, graduate students who are writing their thesis or assistant professors could come here for a day or two during the summer each week or something, and then be, quote, employed by the Bureau to do studies, that I think would not be that costly. That is, wouldn't be costly. You wouldn't have to pay them that much. They might pay you for the right to do that. I just think that's a very good idea if you could figure out how to do it without violating the confidentiality of the information.
All right. Well, I'd like to thank the panel and give them a round of-
You have a really good list of stuff. Things to do.
Great to meet you, Bill.
Marty, thanks. Thanks, me too.
I hope our paths cross again.
I look forward to that. Look forward to that very much.
Always good to listen to you. Pleasure. Yeah, oh, yes, that's great. Thank you. Marty? Oh, there's an picture.
Oh, no, no problem.
Excuse me, I just want to close with a few comments to end. I'm Dave Schmidt. I'm Assistant Director in BE of our Applied Research Group. And I just really want to thank that last panel for really boxing me in with my boss's boss saying that several topics were well above his pay grade, which put them in the stratosphere for me, and Dennis Carlton saying there's very little left to say. That doesn't, give me great hope for instilling you with words of wisdom. But I would really first like to thank everybody, the panelists, the moderators. This really was a very enjoyable, informative, educational day. And we're just really grateful to everybody for your time and effort coming here and sharing your thoughts with us. I especially want to thank the FTC staff who helped set this up, and in particular, a lot of us put work into this, but this really was largely Dan Hoskins' creation. I think he did a tremendous job, and I'd really like to thank Dan for all his effort in this. So I just had a few thoughts on the day, and I think we'll need some time to think about what we learned here today. But I just wanted to go through a few things, and I apologize. My knowledge of musical cartoons is a little dated, and I sort of stop at Schoolhouse Rock, and I can't help but think that at a hearing on merger retrospectives that My Hero Zero probably should be coming up here somewhere, but I can't really remember the lyrics, so I'll spare you and I won't try to sing any of it. What I'd like to do is maybe work backwards and just give some thoughts I had on that came to mind for me throughout the different panels. And I think this last panel, there was a lot of discussion, and I've heard Bill say this many times, and I think it's really a good point, that these sorts of research projects, including merger retrospectives, are an investment that we're making in the institution. And I think it's an important thing to keep in mind. And part of the discussion that happened here in this last panel, I thought highlighted that one thing we need to keep in mind is that when we're making investments, we need to make wise investments. And we can't really just study everything. We don't have the time, we don't have the resources, so we need to be selective. This was a point Orly brought up, that we need to be sort of opportunistic when looking for mergers to study. And I think that it's a really good point that we need to be conscious of, and we need to think not only sort of what's the opportunity, what data do we have, but what do we hope to learn, and how does it relate to, like the point that came up, that certain industries seem to be studied very frequently and others are not studied at all, and do we need to be thinking about whether there are possibilities to expand this analysis to other industries that have not been covered. I also want to highlight, as far as investment goes, that I think research in general, and merger retrospectives specifically, are an investment in human capital as well as in knowledge. And that we have really some outstanding colleagues here in the Bureau of Economics and in the other bureaus that do get utility out of producing this sort of knowledge, this sort of intellectual endeavor. And it's one of the ways that I think we can help compensate people for the huge wage differentials that a number of speakers mentioned relative to some of the alternative ways that we could be employed. And so I think it's really important as an institution to continue to provide those opportunities to give that sort of distinction for this job relative to consulting or somewhere else where you might not get as many opportunities to contribute in that way that I think a lot of people here really value. I'm sort of working backwards through the day. In the third panel, what struck me there is that the theme that I sort of grasped there was that these merger retrospectives have a lot of different audiences, and we need to think about what those what audience we're shooting for when we're starting to do a study. And I found it interesting that Debbie sort of said, well, courts really aren't going to pay much attention to a merger retrospective in a similar industry. That's not going to carry a lot of weight with them. But that might carry a lot of weight with the commission internally. And there was a lot of discussion about the what and the why. And I think, the what might not be of all that much value to courts. And there's a question about, with the commission, do we necessarily care whether this merger caused prices to go up 5% or 7%? We may or may not. I think there's some interesting things from the perspective of an economist, like some of this work on the cross-market mergers that Lemore discussed. Some of the early work in there didn't really have much of a theoretical basis for why these mergers might be causing prices to go up. I credit Lemore and her co-authors for trying to build a theory into it, but I think there's real value in just the empirical finding itself to give economists something to think about, to build the basis for saying, hey, there might be something here. It might be worth thinking about whether this is a competition issue, and others can build on that. So I think like the whole what and why, it gets a little muddied to me when you think. I think what actually can lead you to why, and so I think really the question is, what you have to sort of evaluate. What is it that you think you have to contribute with the particular project that you're working on? So in the second panel, one thing I found interesting was how many of the speakers found that the sort of tools for prospective merger analysis often worked well, but they didn't consistently work well. Linear demand might work well in some case, logit might work well in another. Even guppies or diversion ratios might be informative in some cases and less informative in others. And I had sort of two thoughts on that. One is I wonder if we could be doing more with retrospective analysis to help us in a case-by-case basis determine which of the models might be best in that particular case. So take a particular merger, can you use pre-merger data to do some sort of goodness of fit analysis on the different models, and then use that to project, the best performing model there to project out the effect of the merger. That sounds sensible enough, but it might not be. And if we did that exercise with a consummated merger, we could see, is there some way to sort of do a horse race with pre-merger data that helps us to select the best model to then predict out forward what the effect of the merger will be, and can we validate that somehow using data from consummated mergers? The other thing that struck me in that discussion was, it sort of flows into the first session, excuse me, is the use of some element of structural models to help us estimate merger effects in cases where difference in difference might not capture everything. And I think one thing that's important in doing that is to keep in mind that these merger simulation models that we've estimated and found have varying levels of performance in any given case are calibrated as well as they can be to the specifics of that merger and that market, and sometimes they perform really well and sometimes they don't. And so if we start throwing structural elements into these econometric models that are just estimating the merger effects, we need some evidence that the way that we're throwing structure into the model is actually an accurate description of the market and isn't like throwing a linear demand system into something that should be AIDS or constant elasticity, right? We want to make sure we're not missing the mark. The last thing I want to end on, I think, is a fairly positive note, and it might be taking the risk of really stating the obvious, but in the first session, I think one clear takeaway, and Orly sort of alluded to this, was that, and so did John, that I think we can all take heart that although there are like varying estimates of what the impact of certain mergers have been, one thing that's clearly demonstrated, I think, in the merger retrospective literature is that there are some harmful mergers out there. There are some anti-competitive mergers. And hearkening back to Chairman Simon's opening comments, talking about the strong bipartisan support for merger enforcement, I think this body of evidence suggests that there is strong support for, there's strong empirical support for continuing with merger enforcement. And so I found that to be sort of a positive takeaway. I know it's kind of an obvious takeaway, but I think it is something that this literature demonstrates. So with that, it's 10 after 5, so just thank everyone again, and thank you.